Next, leader.
Yes, ma'am.
The item number 12, then 9,
What about 11?
not 12, but 9,
9.
9, 10, and 14, madam. All these case lists to old pension scheme. Retrieving is pending before this division bench, madam.
Ah,
It is fixed on 24th. Let them be listed after in the month of March.
March. We'll have it on 30th of March,
Yes.
30 March. Letter counsel for the petitioner, Ms. K. Devi, has submitted that a writ appeal on a similar issue is pending before the division bench. Accordingly, list this matter on the 30th of March, awaiting decision from the division bench.
May I plead the lordship?
Yes, sir.
I pray for listing of a tender matter, motion matter on Monday. It has been filed on Wednesday. Obliged, madam.
Maybe Lawson. So item number 65 of supplementary is filed. Was supposed to file a reply opinion matter. The petition is hailing from a remote village of Sipsagot district.
65.
That about Lordship a similar situation, Lordship has already put an order listing the matter in different any other than except your Lordship. Lordship,
List this matter before a bench without me.
Lordship. That was already your. Otherwise, we don't have any objection.
May please, your lordship, may I mention for an urgent listing on Wednesday, tender matter, we filed it yesterday.
Wednesdays.
Obliged, your lordship.
So did you consider the other side? Lordship, I'd like to mention item number 32 of today's daily list.
30?
32. Madam, this matter can come up in the next week. We were supposed to be in our records, but
Ah.
unfortunately, we were not able to get it today, madam. I've requested the other.
The Mr. Fukun Learned Standing Council GAD has made a prayer for accommodation to produce the records. Accordingly, list the matter
First,
on Thursday.
I mean, the
Thursday to 17th, 18th, Wednesday, 18th of.
deeply offended.
That was item number 32.
2.
Yes.
That is not.
Yes, madam.
I recommend item number 7. I have taken control of the other side of it. I've taken out some other data.
Give us a date. It goes to March then.
Yes.
It goes to March.
My lord.
March what side again? At the request of the councils, at the joint request of the councils, list this matter again on 18th of March.
My lord. Deeply lordship.
May I please?
Yes.
I need accommodation, my lord, in respect to item number 73. Today I need to leave with
70?
73, my lord.
You've not taken steps over.
Lordship, I'm appearing for the respondents, lordship. We'll be filing our Wakalat number today.
Okay, your name?
NR Sharma, lordship.
N.R. Sharma, council has submitted that the Wakalat Nama for the respondent number 1 would be filed.
2, lordship.
Respondent number 2 would be filed during the course of the day. List this matter again in March. 12th of March.
Obliged.
I beg to mention item number 30 and 31.
30 and
I'm
For the petitioner, may I payment this matter may be taken on 17th.
on 17th.
71. Lordship.
At the joint request of the parties, list this matter, list these matters again on 17th
There is an interim.
February. Interim order continues till then.
Deeply lordship.
But in respect of item number 69 and 71, supplementary.
69, 71.
In 69, an affidavit in opposition has been filed yesterday,
Mm.
and in 71, a reply affidavit has been filed. Both of that may be called for, my lord. It is not on record. No.
Regard to item number 54, madam.
Mm.
Lordship, in this matter, the copy of the writ petition was received by the earlier sets of council. I am appearing for BTC in this matter. So, my lord, I pray for some time to obtain instruction in this matter. And
Do you have a copy of the writ petition at all? No.
I'm for the petition, lordship. I'll provide a copy.
Supply her a copy. Due to a change in the set of councils, the specially appointed councils have sought for an accommodation to be acquainted with the case and to have their instructions. Council for the petitioner shall supply a copy of the writ petition to the new set of councils. List in, is there any urgency? We'll have it in
Lordship, there
March.
is, lordship, there is some urgency.
Huh?
Lordship, we are challenging an appointment, lordship, the respondent number 6 is confirmed.
We'll have it early in March.
Lordship, it may be, otherwise, lordship, steps are complete. It can be listed in an admission column, lordship. Steps are complete otherwise, lordship.
List for admission on 9th of March. 9th of March.
Obliged.
Lordship, can it be on 16th of March?
16th of March.
Lordship.
Yes.
My lordship, should like to mention item number 8, lordship.
8.
8, lordship. Actually, we are supposed to file affidavit in reply. We are getting hold of some important documents, so some more time is needed, lordship. 1 week.
Lord
Yeah,
Council is
yes.
paying for the petitioner has sought for some time to file the affidavit in reply. List the matter again on 3rd week of March, 16th of March,
Of the lordship.
16th of March.
Lordship, I beg to mention a repetition of tender method. For emergency listing on Mondays, lordship. It was filed on 16/12/2025, lordship.
It has not been listed till now.
Because it has been a objection, lordship, but.
Have you cleared it?
It was clear.
And lordship, pray for listing of a fair price shop matter, lordship. Getting the license of fair price shop.
When did you file it?
5 to 6 days back.
Huh?
lordship. 5 to 6 days back, lordship.
Objections cleared.
Perhaps, lordship.
Find it.
Obliged, obliged.
Lordship, I would like to mention that concern of the other side, I would like to mention item number 58 and 59. And the matters will be taken any other days.
Oh, we'll have to wait till the matter is called for. To 17 and 18 matters, we have to see why the matter has not been heard. We'll not dispose it to your discomfort, but we'll have to pass some orders in. It will come up, we'll see what is to be done.
So as the instruction we have received yesterday, but the instruction was not sufficient.
We understand it is of 17 and 18, we'll have to pass that order once we go through the file, madam. We'll not pass any orders to your detriment is what we are assuring you. We'll give you the time, but the file has to be before us.
May I please, my lord?
Yes,
My lord, by the consent of the other side, I'd like to mention 2 items of the daily list, 2 and 39.
2.
2 and 39. Item 2 and
Number
39.
2.
Engaged senior counsel is unwell, my lord, Mr. M. Sarania, because of which he could not appear.
It is submitted by the counsel appearing that the engaged counsel is not keeping good health and is not in position to appear today. Accordingly, list this matter on March
Last week of March, any date, my lord.
30th,
Obliged.
27th.
27th. Obliged.
May it please your lordship. Lordship, I beg to mention for listing of a writ petition. Can it be on Wednesday, lordship?
What kind of a petition? Which
Lordship,
batch?
I'm a license holder of a fair
When
price
do
shop
you want it?
on Wednesday, lordship.
Wednesday.
Yes, lordship.
May it please the lordship. Lordship, in respect of item number 57, we had circulated an adjournment slip yesterday. Lordship, the similar matter is been listed before the coordinate bench of this court. But those two
You just say the adjournment slip has been circulated with consent.
with consent.
Accordingly, list this matter
One
again on. When?
1 week,
It will go to March.
March, lordship. Lordship.
Lordship, I for the respondents matter. Lordship, I for the respondents.
Ms. Swenso appears for the respondents. 2nd of March. Huh?
2nd of March, lordship.
Lordship, I'm being led by the senior counsel, Mr. K. Chaudhary, so we might not be available on the 2nd. Which could it come up on the 3rd or 25th?
Of this month. This month we have 2 full, madam.
March is fine.
Subject
lordship.
to your
25th paying की बात आ रही पैसे.
March is
Content pension addition की वो सब. Yes. 25th of this month.
interim is there, lordship.
Interim order continues.
Obliged, lordship.
What special negation right? I think 6.
Mediation.
Yes, my lord. This is regulation matters, my lord. He has 27 years of service, then not regularity spending for quite some time. So today also the opposite party, NIP Silchar, is absent.
None appears for the respondents on call. The Honorable Counsel for the petitioner submitted that the petitioner is ready for agreeable to approach the mediation center. Accordingly, list this matter again before the mediation center on 27th of February, on which the parties may appear before the mediation center registry to do the needful.
Obligation.
Yes.
Let us relate to the.
No, can we go for mediation? One short question and one short answer.
63 or 3. Oh, sorry, Your Lordship.
Yes, do you want a mediation in this matter?
Yes, Your Lord.
Miss, your name
P. Kalita, on behalf of Mr. S. Das.
has submitted that the petitioner is eager to attempt a mediation in the matter. Accordingly, list this matter before the mediation center on 9th of March, on which the parties will appear before the mediation center registry to do the needful.
Obliged, Your Lordship.
65.
65 to হেৰি হয় দেখোন admission হয় 64 হ'ব 64 এইটো 64 ফাইল মোক দিলে 64 মোক দি থৈছে আপুনি 64
I'm very for responding.
Would you prefer a mediation in this?
So far as the prayer portion is concerned of the writ petition, Lordship, even Lordship, if Lordship allows this writ petition, Lordship, then also Lordship, we don't have any objection. So, my Lord may kindly come to prayer portion, serial number 2. We are directing the respondent authorities, particularly the respondent number 2, 3, and 6 to release the family pension and other pensionary benefit arising out of the service so and so to the petitioners and to the respondent number 7 at equal.
Yes, what do you say? For the pension department. This is compassionate family pension or direct pension?
Compassion.
It was compassionate family
Yes,
pension.
Lordship. There is an order, Lordship, whereby department.
No. Is it compassionate family pension? What we are asking is the answer you give us. There are two
Yes.
pensions.
Yes,
There is one pension.
It is compassionate family.
Then the respondents have to take the decision. The department has to take the decision.
May submit. Here, Lordship, what had happened, Lordship? Department had taken.
We'll have it for admission on in March, 6th of March. In the absence of the petitioner,
Yes,
can
yes,
be complete.
Already clear.
None appears for the petitioner on call. Mr. So-and-so on a council has submitted on behalf of the respondent number 7 that the respondents would have no objection if the second clause of the prayer
Yes.
of the writ petition is allowed. List this matter again on the 6th of March 2026, allowing the petitioner to appear so that the matter can be taken up for disposal. Mr. Bora, Mr. D. Bora appears for respondent number 3.
Item 1.
May it please your Lordship. Lordship, it's a recovery matter. And we were able to establish contact with the client just yesterday. And it was intimated to us that the order of dismissal dated 12/1/2015 has been set aside by the Honorable CAT, your Lordship.
Honorable, in appeal.
Thereafter, it was directed de novo. Now disciplinary proceeding has been concluded, my lord, in the month of February, January 26.
The inquiry has been concluded.
Fresh DP was directed.
And what happened in the DP?
Has been concluded, final order is awaiting.
So the inquiry has been concluded.
Concluded.
Proceedings have not been. The order is to come.
Yes.
But then if the recovery was by an earlier order, can you retain the money? If that earlier order has been set aside?
That averment regarding retention of money, my lord, that we have denied it. Only 10,000 has been recovered so far. The averments made in the writ petition that 16 lakhs have.
This is item?
That is, that has been denied in the.
Just a minute. This is item 1.
Item 1.
1 year.
Let us see quickly if we can find something.
Paragraph 18, my lord.
No. What is the allegation? Letter that since issued by the inspector of the personal support officer. Yes, this 16 lakhs.
Your
What has
Lordship,
happened? How do you say it is 16 lakhs? Are you prepared with the matter?
Lordship, kindly grant us some time to file our affidavit, citing on records the order of dismiss, Your Lordship.
No, he agrees to it. He says that yes, that order was set aside in appeal and we had gone for a fresh inquiry. That is another part. Tell us from where you are saying that the 16 lakhs have been recovered. Just tell us, sir.
Your
Or is
Lordship,
it a case where because of the dismissal, the retirement benefits were not paid? And she thinks it is a recovery. Is it that? Is it so? Yes.
Lordship will take up the matter after some time. A senior will appear, Your Lordship.
We have categorically sitting in the affidavit, only 10,000 has been.
What have, 10,000 has been recovered, you give it back to him. If that order of recovery was a part of the disciplinary proceedings which was earlier done, give it back to him. That you cannot retain once that order goes. Once that order goes, you cannot retain it.
Fresh DP was
That is a separate matter. You can impose penalties.
May I pray, my lord, if the final order is awaited, my lord will take it after. Negative, my lord.
Just a minute. Where does she say that 16 lakhs have been recovered?
Paragraph 18, my lord. Paragraph 18, the liquidation.
Deducted from petition's retirement benefit. Where is that order? Dismissal.
Lordship.
When you are dismissed from service, where do you have retirement benefits? So it is not a recovery. You were not paid. If the dismissal order had been set aside by this court, then you would be entitled to the pension and the pensionary benefits. In a case of dismissal, you are not. So would this writ petition in fact be of any use once the order has been set aside in appeal? You'll have to challenge any fresh DP which has been initiated, or you have to.
Fresh DP is concluded.
That is what I'm saying. Either they have to challenge the initiation of the fresh DP itself or the culmination of the same. Earlier writ petition does not survive. Have your instructions from your
Lordship may take up the
counsel
matter after some time.
after something else. But this writ petition, in our view, does not survive any further because the order has, if you file that affidavit saying that that order has been set aside in appeal, what remains in this writ petition? Nothing. You can close it today. You will have a quicker opportunity to approach the court on the next, with the next writ petition. Yes, item 3. 2 to key hole. A time dole, no? Time dole. Huh?
93, Your Lordship.
Ah.
We are going to be filing our affidavit, my lord, during the course of the day. We have sent it for.
If not filed during the course of the day, 5,000. Then 5,000. Okay, Monday.
Monday.
Then on Tuesday, it is 5,000. If not filed by Monday, 5,000. Yes, what do you say? Someone has filed an affidavit in opposition. Who?
Irrigation department.
And what do you say? Huh?
They have to decide the.
And why this Gajendra Kumar Rai is roaming about in this file?
This is a covered as far as the Gajendra Kumar Singh.
If it is covered, then?
Dinesh Kumar Singh, this is a cover. On the last occasion, my lord, the court had directed us that final affidavit because we had produced a instruction saying that the GAD is not the concerned authority for him because of the fact that his appointing authority is the irrigation department. So
And
therefore,
irrigation department says, no, 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 no.
that is why my lord.
This,
Let
Lordship.
it on record, my lord.
We asked him what is Gajendra he has given us.
Lordship, Dinesh Kumar Singh.
He's building up his army. Can you, huh?
This question already, this question, Lordship, already covered by the paragraph 22 of this judgment, Lordship. Kindly peruse the paragraph 23 of this order, Lordship, just I have referred, Lordship. This judgment, Lordship. Paragraph 22, page number, internal page number 9, Lordship, of this order.
You are not serving in which department?
Irrigation department, Lordship. There's a gate.
And why is irrigation department not promoting him?
Lordship, this is.
So has he got his, he has got his MSCPs and ACPs and everything.
I don't.
He was originally appointed by you.
No, ma'am. He was, that's what, I'll bring that on record. He was appointed by the irrigation department
Huh?
and appointed by an undersecretary, which cannot, that is, he was.
Now you will not question his entry into service at this point of time, sir. The persons who allowed him to serve will be paying back all the salary that he drew in case we hold him to be illegally appointed. Why did you allow him to serve for so many years?
32 years is, since last 32 years is now they have questioning regarding
March.
this.
10th. List this matter again on March 10th at the request of the learned counsel, of Mr. A. Fukan, learned counsel appearing for the GAD department. The counsel has assured that the affidavit in opposition would be filed on or before 16th of February 2026. If the affidavit, in the event the respondents fail to file their affidavit on or before 16th of February 2026, they are put at notice that they will be liable to pay up cost of rupees 5,000 for delaying adjudication of the matter. The petitioner would be at liberty to file reply to the affidavit in opposition before the next date of list accordingly.
Item 4.
2021. Yes. Yes, sir.
May it be lordship, my lord.
Hmm.
Here the workman was transferred, my lord.
Hmm.
Before that, there was one conciliation proceeding going on
Hmm.
the allegation of some deduction of unauthorized deduction of bonus of the workmen, other workmen. So while the conciliation proceeding was going on, the order of transfer was passed from one unit to another unit. There has been challenge and that was referred by the government. That is at page 12 reference.
Hmm.
Page 12, Annexure A.
The transfer was in the year 2013.
Hello?
Transfer is of the year 2013.
No, 2009.
2009. Then what happened?
Then my Your
From
Honor,
9 to 13, what happened? He went and joined.
he didn't join. He didn't join. In the meantime, he initiated the proceeding. Reference was made, and after reference, the award was passed. I produced the witnesses, filed the WS also.
And it was held against you.
Yes.
Then what happened?
The award is yet is 26 onwards. But the learned tribunal has not dealt with the details of the earlier consideration. The very long order, but
Now after they held that you should have gone and joined.
yes.
So now from 2009 transfer order, now in 2026, does the cause remain?
He has joined in another post.
Huh?
He has joined in another post. With higher scale. In the meantime, he might have retired, madam, because it is a.
That was a submission on the last date. Since you were making submissions, we thought you had instructions to continue the matter. Have you?
No, I have instruction to continue because if,
So now if
it is
we
held to be
interfere with
illegal,
this-
the award is illegal, then I may get some compensation. That's why
Huh?
I may get some compensation. I may claim that.
They are not present, none for the respondents. Is it
Yes.
any names shown? GA Assam. Eh? You're for the Labor Commissioner. Your order is under challenge, no?
Management.
Has notice been even issued to management?
They appealed on last occasion. I think their names.
No, none appears for the respondent on call. On the last occasion, H. Sharma for 1, 2, and 5.
Yes. Which one? নাম show করেছে তো?
Huh? Three has been served, they are not appearing. Heard Mr. Apish Sharma, learned senior counsel, appearing with the assistance of for the petitioner, Mr. D. Bora is Mr. D. Bora, learned GA is present on behalf of respondent number 125. None appears for the respondent number 3. Admit the petition. List for hearing on 17th of March.
Because, hello,
10th of March.
God willing, I may be.
Oh, then although we would like you to be there, but we would also miss you here in that case.
Hello.
When do you want it, sir?
First of April. First
Huh?
week of April. First week of April.
First week of April. We have only 2 dates on first week of April, 1 and 2. We'll take it up on 7th. 7th of April, 2026. Full stop. None has appeared for the respondent number 3, although notices were served. Yes.
Double M.
We'll take it up. Yes.
Pass over for the timing.
Item 5, she has sought for a passover for the time being. We have allowed it.
May I please your lordship, my lord, please adjourn the matter today as my learned counsel is unwell.
What is the matter relating, madam?
WBC.
Mr. Nayak, I don't think she will be. We have seen the synopsis.
Yes.
We'll afford her one opportunity to go through the writ petition in the absence of her senior today. She might not be experienced enough to resist you. We'll give her an opportunity on the next date. Whether the senior is there or not, we'll take up the matter. You be prepared with it. Because we have noticed on 9/1/26, you have taken time. Is it not?
After 2 weeks.
You pick a date, but we'll hear you in the absence of the senior. Tell us a date. You choose a date. When is the date?
25.
25th of February. At the request of the learned counsel for the petitioner, Miss, what is your name?
And Sudhuri.
And?
And Sudhuri.
List again on the 25th of February, 2026. She assures to be prepared for the matter. Yes, read it. Mr. Pinak, Additional Advocate General, appears for the respondents.
Lordship, in item number 11 and 12, we'll file the rejoinder affidavit to the counter filed by the finance department. One is on record, the other one is not on record. So may I please that let it come up on record and the date may be fixed?
Then it will be sometime in March.
No issue.
10th of March?
Any day.
10th or 12th? 12th of March?
Yes, sir.
Mr. Sinha has, Mr. R. Sinha, and counsel appearing for the petition has submitted that although reply affidavits had been filed in both the matters, only one of the replies are on record, full stop. Accordingly, he prays that the matter will be taken up after both the replies are tagged. List this matter on 12th of March, 17th of March. 17th of March 2026, allowing for the matter to be placed along with all the pleadings. Mr. So-and-so appears for the Director of Higher Education. Your name? Z.R. Mazumdar. Ms. Z.R. Mazumdar appears on behalf of Ms. P. Agarwal, Standing Counsel, UGC. Yes.
Deeply obliged.
Next.
Yeah, Your Lordship. In this matter, my senior will appear. Kindly pass over the matter for time being. That's what we do.
Objection.
I'm ready, my lord.
Objection to the passover for the time being. Should not. Yes, sir.
Now, these are all matters pertaining to whether these persons are entitled to benefits under the old pension scheme. The law is otherwise very clear that if the recruitment process had started before notification of the new pension scheme, these people will be covered under the old pension scheme. Initially, though they were not a party, in the Delhi High Court, there was a list presented by some writers where around 3,800 people's name were included, and including these petitioners. But then subsequently, when the exercise was actually carried out, only around 1,100 persons were considered. The rest were left out by saying that we don't have
Read orders.
records of the advertisement.
Huh? Record of the advertisement they are missing.
They are missing.
Very well. Yes.
Now, the affidavits also now indicate in two places. In some places, they say that the advertisement is not found. And in some places, though, they say that no, it is 2004 advertisement. But then the recruitment rallies were directed to be conducted in September 2003. So therefore,
So it cannot be 2004.
it cannot be 2004.
If you have got the admit cards for the particular rallies, matter ends.
No, difficulty is that we also don't have the admit cards. So the records have to come from their side. We were also not expecting this scenario to happen. Nobody had retained this.
There are other matters, my lord. I appear for item number 20. There are other matters where affidavits are not filed.
There are three other cases. There are three other cases.
Should we have all the matters taken up together?
Yes, I will furnish the numbers then. Three others are not listed today.
But those
Three
cases,
cases affidavits are
no,
not.
it would help this court better if you can segregate petitioner wise those who have got some call letters prior to 2004.
Yes.
For them, we will not hear them to say that it was done. It was an advertisement of 2004.
Yes.
2003, if we get those numbers, we can say these are what we tentatively feel are entitled, unless they can dispute it.
Yes.
For those after 2004,
So
that is what we will see. That
appointments-
exercise has to be done by the petitioners.
There's no dispute that otherwise the appointments came in 2004. But then the process
Yeah.
started.
So now page 79 of this petition, I don't know, 6153 of 2024. I just turned the page and I saw this.
Yes.
This is some document of 31st of December 2003.
Yes.
Now, if the admit card or anything which shows that it is prior to 2003, recruitment rally takes place over a week or two
Yes.
at the minimum at a particular place. Then they will be going through the medical tests and all the other tests, and then the appointment letters would be issued, giving them 15 days time minimum to join.
Yes.
If it is in the month of February, the recruitment had to start before 2004.
No, we'll place those charts. We'll
Whatever
prepare-
chart,
we'll
if
prepare
you
chart
can,
wise.
come up with those
Yes.
charts, it would be easier.
Yes.
Now, this at page 227. This is a list given when? Given to whom? This is a part of what?
227.
Huh?
227 and but this was the list before, I think. This is the people they have considered.
Now kindly see.
They have considered.
This is why we find the CRPF a bit better in this aspect.
Yes.
CRPF, they start with the year,
Yeah.
89. The first numbers are given on that manner.
Yes.
In Assam Rifles, it is different. They start with LM, NOP, I don't know why.
Because
Can we not trace it out from that part as to when could the recruitment have been? In the other forces, you would have a force number.
Yes.
The starting is always the year. Then there is a, I think, battalion number or something, or a group center number, and then the serial number of the person comes in.
Yes.
That is how they can identify the person at one go. That he is in 89, his battalion was this, the records will be in that code,
Yeah.
in that battalion. If we can find out how the numbers in the Assam Rifle is given to indicate, how do you, there may be two Shekhar Das. How do you identify? This 227, the first name is 27-1-2004. Is it not? At
Yes.
page 227.
So to say.
He has to be prior to December 2003. In the absence of record, we have to go by what
No, in
seems to be.
227, the first page, I think if this name Dharampal Singh, if
Ah.
you read, Dharampal Singh's, the advertisement was found. So it was a specific case where advertisement is of 13th October 2003. But then if Lordship comes to the bottom
no,
of
sir.
that particular list.
Just look at it at page 224. Do you find it page 224?
Yes.
Date, the last but one column. Date of joining in government service.
Date of joining.
In most cases, if it is sometime in January, the selection process has to start in 2003.
0004.
Is it not?
Yes.
Once we have the date of joining of these people,
Yes.
not the date of appointment. The
Yes.
date of joining would help us a lot. Date of offer of appointment will help us a lot.
Yes.
Advertisement, we do not know because
Those dates are there. Those dates are there.
then why do they need the advertisement if we can trace out something from that?
Because in other cases where they have considered, if a lordship comes 281, in
281
281 lordship
means-
will see that some cases where towards the bottom of page 281,
Ah,
advertisement not found, even
Ah.
then these people were considered. And these people had joined in March 2004.
so that is what respondents simply saying we don't have the advertisement is not going to help.
It's not going to help.
A similar list, that is why I asked you for that number.
Yes.
The number indicates when he joined. If it does, I do not know how they give that number in the Assam Rifles, but there has to be an indication how to identify the person. That has been coming on from the times of the British. They always knew which Indian is appointed when, and this is the system followed. Now, if they could find out something, advertisement date is not found, but 18/3/2004. If we can show, or if this court can come to a conclusion that this is the recruitment process in which he was appointed, you have a case. Otherwise, we'll have to say disputed facts closed.
We have a document which directed that these rallies are to be conducted, and this was in September 2003. But in
And
the specific
the order
date-
that I had pointed out
Yes.
is of December 2003. So till then, the process was only on that we should conduct it.
Yes.
It will not be to your help.
It gives an indication.
It is yet
but
to
then
be started.
What are the exact dates? Therefore, the records, they have taken a.
They say they don't have records.
That cannot be. That cannot be. And in some cases, without records also, they are considering.
That would be negative equality.
Date of
I will not go by that.
notification.
Huh?
Date of advertisement notification is after 22/12/2023.
Huh?
That is.
How do you know?
Or if it. if it is-
Or for all of them?
How?
Identify. Identify.
No, let all the other CGSs be there. So everybody is holding a different brief. 3 other cases affidavit are yet to be filed. I furnish those numbers, then we tag all.
You can have it within yourselves. You can find out that these are the persons. For those, there is a confusion. Maybe, just maybe, I don't know. Withdraw for the persons with confusion, whether we let the orders be passed in the persons who have the,
No,
where we can identify them.
Definitely, this has
My
to be
friends,
posted on basis of records only.
those who are under a confusion continues to fight. Why everybody? Take it like this. Mr. B. Pathak, Learned Counsel, appearing for the petitioners have submitted that there are other writ petitions also pending on a similar issue, where in some of the matters affidavits have been filed, and in some the affidavits are yet to be filed. Mr. G. Pegudan at CGC also has made a similar submission. Accordingly, list this matter along with WPC number.
It says furnished.
Just give the numbers. When can you find the affidavit by? In all the cases, you are not appearing in them. On 23rd of March.
Well-
On 23rd of March. Yes, along with WPC number so and so. Kindly also go through if those writ petitions, any date is fixed. We'll change the date to that. Yes. Yeah.
Item 1.
Late season, my lord. Well, my sincere apologies for not being there. in matters proper. My lord, the matter pertains to recovery, lordship had put the query from where the value of 16 lakh. My lordship may take up the last annexure, my lord, annexure F
Of?
of the writ petition, my lord. Page 70, last page.
Yes.
It's dated 25/01/2017. Addressed to the circle officer. It says, sir, with reference to the subject cited above, it is to be submitted that Srimati Anjana Phukan, the then postal assistant, Amguri sub post office, had misappropriated government money amounting to rupees 16 lakhs. And an amount of 2 lakh is yet to be recovered against the loss sustained by the department, as intimated by the SPO Nalbari Borpeta Division, Nalbari, and it has become imperative to grill her under PAD Act to recover the loss sustained by the department. Therefore, you are kindly requested to intimate the particulars of the landed property in the name of Srimati Anjana Phukan and her family members for further necessary action at our end. Because, at first, my lord would notice this notice is addressed to this recovery is against the petitioner, Anjana Phukan, who was the employee, my lord, as well as her family members, my lord. And it was not preceded by any notice, my lord. And in fact, my lord, how 16 lakhs was assessed or determined.
Once you are dismissed.
Yes.
Once you are dismissed. What do you take home?
Yes.
What do you take home once a person is dismissed?
The provident fund, maybe. Not the gratuity and
Goes. Leave salaries, goes. Dismissal, everything goes. So there is nothing to recover from. Is it not? Now they say 14 lakhs was the estimated amount, and out of 16 lakhs, 2 lakhs remain to be recovered. Dismissing you, they have retained back the money. We cannot hold fault with that. 2 lakhs you are supposed to pay under the PAD Act. They are doing some action. We are not concerned with that. Now, admittedly, this dismissal order has been set at naught. So unless and until the fresh inquiry order comes, you have no cause of action as of now unless you tell the court that yes, we are challenging that earlier disciplinary proceeding.
no. In fact, disciplinary proceeding was challenged before the Honorable CAT. Now we approached this Honorable.
They've allowed the appeal.
They've allowed the OA, my lord, original.
They've allowed the appeal. Whatever you have found.
Subsequent filing of the will.
They have allowed it. Now that order is gone.
Yes, yes.
That earlier
Yes.
dismissal order is gone.
Yes.
Fresh de novo inquiry was allowed.
Yes, that I have to take
Unless
instruction.
some penalty comes on the fresh de novo inquiry or on the inquiry itself.
Yes.
You have no cause of action till now.
No, my lord, this writ petition has been filed, my lord, that this letter, my lord, that letter itself is without jurisdiction because it is not.
We will hold so, but we cannot hold that there has been any inquiry with any recovery from you.
Yes.
Because till now,
Yes.
you are still under the inquiry.
And my lord, the husband of the petitioner is also a writ petitioner here, my lord, because this recovery.
Could be. Once that
yes.
order of termination goes from the CAT, now it is an inquiry that you are facing. Whatever happens in the inquiry can be a subject matter of challenge. But this writ petition, where does it stand today?
So this is, my lord, I couldn't prepare properly, my lord. I just took instructions yesterday. My lord, it seems, my lord, this is basically assailing the action of my lord's recovery under the PAD Act, my lord, which is unsustainable.
Listen to us.
Yes. And that dismissal.
That
and
order has gone.
Yes.
Dismissal order has gone.
It has no
This-
nexus with the dismissal, this order, my lord.
Which one?
This annexure.
That is what we are telling you.
Yes,
Recovery from where?
yes,
They could not have recovered anything from anywhere.
yes. Yes.
So this petition goes.
No, my lord, recovery is from like areas of land revenue. If my lord peruses the act.
No, it cannot be.
Yes,
Now
yes.
please see this.
PAD Act, my lord.
Please see this.
Yes.
It is good to have a discussion with you because now have annexure F again.
Yes,
PAD Act.
yes. Public accounts,
Ah,
public default.
Public Accounts Default Act.
Yes, my lord.
Right?
I have quoted the provisions.
Now listen to me.
Yes,
Unless that PAD Act, some enquiry is completed,
yes,
they cannot recover from you.
yes, yes,
They have said, give us the land revenue thing.
yes,
Is it not?
yes.
We will just observe in this writ petition saying that this PAD Act, that calling of that information
Yes.
is only a step in the process.
Right.
No result from the PAD inquiry has come till
It
date.
shouldn't be agreed.
So therefore, as of today, you being premature and their attempt to make a recovery without completion of the inquiry itself is bad. PAD is completed. Please, we are talking of the PAD. Why are you interfering with the disciplinary proceeding? For this recovery of 30%. No. Whatever is of this 15th of January 2026 or whatever recovery you want to make, is it under the PAD Act? Is it under the PAD Act? Then why are you interfering? Give us something, join the discussion, don't disrupt it. Join the discussion, we like it. So this part you can challenge.
Yes, yes, yes.
That is one portion of it. This part, this writ petition does not survive is what we are saying you.
Right.
All the liberty to you to go and get this disposed of.
Right, right.
Challenge it and get it disposed of.
Yes. I couldn't properly go through the PAD Act. My lord, is it that
It cannot
determination
unless
is the determination made in the disciplinary proceeding, or there has to be a separate?
no, they what do they say?
Separate.
It has become imperative to grill her under PAD Act.
There has to be a separate determination.
Now this loss was
Right.
determined in the earlier disciplinary proceeding, assuming they can do it, they can make a recovery through the PAD Act because of the disciplinary proceeding. What happens? That order is gone.
Gone.
As of today, no recovery under the PAD Act based on the earlier disciplinary proceeding. Writ petition closed. Granting you the liberty to challenge 15-1-2006. 2026.
Yes,
Is it not?
yes. And my lord, the setting aside of annexure F may not be required. My lord, because, no,
Setting aside of?
of the order which was impugned initially, the annexure F.
No, that has been set aside by the CAT.
No, this order, this annexure F, writ petition order, my lord, the recovery. But
We will simply say that they had come to some conclusion based on the disciplinary proceeding. This order on which they had based the calculation is now gone in law. It does not exist. Therefore, this 25-1-2017 has no legs to stand on. And therefore, 25-1-17 is set aside.
the allegation of defalcation was an amount of rupees 5,49,000. But how come
When we
60
set aside 25-1-2017 as a whole,
Yes,
because it was based on an order passed in a disciplinary proceeding. Disciplinary proceeding order goes,
both, exactly.
25-1-17 goes, new DP has been taken up, it has been brought to our notice, liberty to the petitioner to address her grievances in appropriate forums.
Very well, very well.
Is it?
Yes,
You cannot do it now under this 17 thing. In any case, you are saying you are not recovering. So the flow of water we will take into account. 17 writ petition does not need to survive.
this has to go.
We are not pressurizing the order on you,
No,
are we?
not at all.
Huh? We are not pressurizing an order on you, are we? Heard Mr. P. Mohanto, Learned Counsel, appearing for the petitioner. Also heard Mr. H. Gupta, Learned Counsel, appearing for the respondent. The order assailed in this writ petition is the communication assailed in this writ petition is dated 25/1/2017 issued by Office of the Inspector of Post Offices to the Circle Revenue Officer, Tihu Revenue Circle, intimating the Circle Revenue Officer that the petitioner had misappropriated government money amounting to 16 lakhs and an amount of rupees 2 lakhs was yet to be recovered against the loss sustained by the department as intimated by SPO Nalbari Borpeta Division. Therefore, a request was made to the Circle Revenue Officer, Tihu Revenue Circle, to intimate the particulars of landed property in the name of the petitioner and her family members. Full stop. Mr. Mohanto, the counsel for the petitioner, has submitted that this amount of the alleged amount quoted in the communication was based on an inquiry which was conducted against the petitioner by the respondent department, and in which departmental inquiry the petitioner had been imposed the punishment of dismissal from service. Full stop. This order of dismissal from service was issued on
Dismissal was issued on, my lord.
12/1/2015. Full stop. Mr. Mohanto, learned counsel, has submitted that after having put the order requiring the Tihu Revenue Circle to furnish the details of the petitioner and her family members had been assailed in this writ petition, and simultaneously the order of termination imposing a penalty of termination from service on the petitioner had been assailed before the learned CAT, Gauhati. Full stop.
OA number.
Mr. Mohanto has submitted that the original application
Number 317 of 2015
had been
disposed of on 13/11/2017, my lord.
by the learned cat, setting aside the order dated 12/1/2015.
Directing de novo inquiry.
The learned cat had directed a de novo inquiry by the had directed or permitted?
The respondents are directed to complete the inquiry after giving.
No. Prior to that, were they given the liberty or were they directed?
Directions, my lord. Respondent
Was directed to conduct a de novo inquiry into the allegations against the petitioner. The said inquiry, it has been submitted by Mr. H. Gupta, has been brought to a conclusion by passing of the order dated 15th of January 2026, whereupon fresh penalties have been imposed upon the petitioner. Full stop. Mr. Pohanto, learned counsel for the petitioner, has submitted on a pointed query by this court that the relevance of the order dated 25/1/2017 may now no longer be that there might no longer be any relevance of the order dated 25/1/2017 since the findings on the basis of which the quantum of recovery had been assessed has been interfered with by the learned cat. Stop. In such situation, where this court also notices that the letter dated 25/1/2017 was only a letter asking for details of the landed property in the name of the petitioner and her family, would not as such require interference, except that now, on the face of the fact that the impugned termination order where the calculations had been arrived at has been set aside by the court, it can no longer be proceeded with. Full stop. Mr. H. Gupta, learned counsel, appearing for the respondents, have submitted that the recovery, if any, from the petitioner because of the new order passed on 15/1/2026 will have been taken up by the respondents afresh if such recovery is sought to be made. Full stop. In such view of the matter, this court is of the considered opinion that the respondents need not proceed with the attempt of recovery made by the letter dated 25/1/2017, if any, and therefore the said letter is and therefore it is directed that that the Circle Revenue Officer, Tihu Revenue Circle need not proceed any further with the requests made by the letter dated 25/1/2017. Full stop. Since it has been submitted before this court that a fresh penalty has been imposed upon the petitioner of course would be at her liberty to assail the fresh orders passed against her, if any, in accordance with law, and the closure of this writ petition would not affect her rights in any manner whatsoever.
Very grateful.
Huh?
Deeply obliged.
Writ petition disposed of. You take up that issue.
Yeah, deeply obliged.
Mr. D. Bora appears for the respondent number 4 and 5. This will be at the top, along with the attendance at the top of the order. Baki bilakor presence lipute. Last tat mein likhibo.
Deeply obliged.
You want to take this back?
Well,
No, I will not. In this case, I will not. The moment we take it on record, this court had taken it on record, and therefore, no therefore's argument. Let it be there. He'll challenge it. Yes, sir.
The case of seniority, Milord, seniority over some persons, Milord, where is there, I see, I require to make some of the person parties, Milord, in this case. So I'll pray for 7 days time, Milord, to amend the petition by including those persons as respondents.
Mr. D.P. Cholia, learned senior counsel, appearing with the assistance of M. Roy, for the petitioners have submitted that an amendment to the writ petition is felt necessary to impede some of the necessary parties. Full stop. Accordingly, he prays for an accommodation to be allowed to file an proper implement petition. Stop. Ms. M. Bhattacharjee, learned additional senior government advocate, does not oppose the prayer. However, it is noticed that the affidavit in opposition has not been filed. The respondents would be at liberty to file their affidavit in opposition in the interregnum list along with the IA proposed to be filed by the petitioners. We are not fixing any date. It will come up with the IA, then we'll fix a date. This is where he is. Yes, sir.
This matter relates to promotion of the petitioner, Your Lordship. If Your Lordship comes to first page 41, she was in fact Your Lordship junior assistant. If Your Lordship will kindly come to 41, that's a gradation list prepared by the board, Your Lordship. My name appears at 2, serial number. It says, Your Lordship, may kindly go through the remark column. Promotion was due, but promotion was held up due to violation of punctuality on office attendance, and the matter of promotion was placed before the board meeting for approval. She was also granted earned leave during so and so, so and so. Now, Your Lordship, thereafter I made several prayers for my promotion to senior assistant, Your Lordship. Your Lordship may kindly come to the affidavit in opposition filed by them, Your Lordship. Just, Your Lordship, the point which
Yes, page
page
number
66.
66.
66. It starts from the, Your Lordship, page 65, my notes. Your Lordship will kindly come to middle portion, Your Lordship. On examination, then next, fourthly, Your Lordship will get fourthly. Fourthly, Managing Director placed the name of following junior assistant along with eligibility criteria required to be fulfilled to be promoted to the post of senior assistant. Now my name at serial number 2. Then the members of the committee had gone through details of the eligibility required to be fulfilled by above mentioned junior assistant for promotion to the post of senior assistant. During discussion, it was apprised by the managing director of the corporation that as per notification issued by the Government of Assam recently, in order to make recruitment to the post of junior assistant, the qualification of graduation is required. Though the above mentioned incumbent possesses the qualification of HS pass only, they were recruited to the post of junior assistant member prior to the issuance of GOV notification. After threadbare discussion, the members of the committee decided to forward the matter of promotion to these two incumbents to the GOV for consideration of approval in this regards. Now, your lordship, thereafter what happened, nobody knows. And in fact, so far as my instruction goes, government says that we don't have anything on this. That is what my instruction, but I don't have the copy. But even otherwise, it's a board, autonomous body, your lordship. Government has nothing to do with that. And the fact that, your lordship, presently junior assistant post requires graduation has no link with our appointment as junior assistant, your lordship. And this senior assistant is
Presently,
pure
presently, junior assistants who are to be freshly recruited need graduation.
graduation, the Assam
You are-
government.
You are junior assistants appointed prior
Prior
to
to
that
that, your lordship.
with
but
higher secondary. You are seeking promotion to which?
Senior assistant, your lordship.
Senior assistant.
Senior assistant. It's a purely promotional post.
It's a board,
It's a board,
so we can take it to be at the directorate level.
lordship. It's
a board for the
completely a
state.
board, autonomous body constituted by the.
Yes, tell us,
My lord, just go by the rules.
which rules
My lord, the service rule of the board.
of the board?
Yes,
Ah,
they have. My lord, we cannot. My lord, I have just flagged it. My lord, in our affidavit, that minuscule meeting, my lord is clear that we have, since we could not, that is why we have sent it to the government. Now, coming back to my lord will come to serial 10, clause 10, my lord.
Yes, see,
Here, my lord, 10A, for the post of assistant development officer, he must be a graduate with 5 years of experience. My lord, my lord, this implies to assistant development officer. Why? Now, my lord, take the next page, my lord. 13. This is promotion, my lord. It's a so now, my lord, coming back to 6, down below, 13, 6. Junior assistant, recovery assistant, junior assistant, recovery assistant, assistant to ADO and senior assistant. So, my lord, the petitioner is the junior assistant. She needs a promotion to the next level, senior assistant. This is, my lord, it's covered. Junior assistant to senior. So, my lord, this needs graduation for promotion.
you are appealing for whom?
I am appearing for, my lord,
The board.
Board.
The board, the corporation.
These are same, my lord. This ADO and this assistant development officer and senior assistant, same way.
Let us again read the whole thing.
My lord. Which one, my lord?
At 10,
10, my lord.
can we read the whole provision?
Yes, my lord. Let us, my lord. A candidate from direct recruitment to the service shall not be less than.
No, 10.
10. The academic qualification and experience of candidate from direct.
So this 10 is for direct recruitment.
Direct recruitment.
Yes, my lord.
We hold it there for 1 minute.
Yes.
Hold it there for 1 minute.
Yes.
So 10 has nothing to do with the case of the petitioner so long it is a case of promotion and not for direct recruitment. The only connection that we have is for direct connection, you need graduation.
Graduation.
Now let us read 13 again.
Yes, ma'am. Promotion, ma'am. Vacancies in the career of district development section and accounts section from one career to another shall be fulfilled by subject to security of maybe on by function setup section development section. So, my lord, from 13, this 6 junior
Just a
assistant
minute.
/ recovery assistant to ADO senior assistant manager. So, junior assistant to senior assistant manager.
Now,
Yes.
vacancies in the cadre at administrative cum development section
Yes, ma'am.
from one cadre to another shall be filled up subject to suitability. So that suitability will be on the APAR. Let us say it is the APAR.
Suitability, my lord, education qualification also come by
Oh,
law.
we are coming to that. We'll
Yes.
come to that.
Fine.
It will be the APAR. What we Kindly listen to us fully so that we can make you know what is in our mind.
Fine,
Then
fine,
we can
fine,
discuss.
fine.
Suitability as may be decided by the board. You must need very good for the last 3 years, 4 years, 5 years.
Fine.
And you must also have a recommendation that it is a fit for promotion. That is suitability. May be decided by the board and by the appointing authority as set forth in Rule 14. Okay? Then 14 and subject to possessing qualification and experience as
Prescribed hereinafter.
hereinafter. So for the promotion part, hereinafter will come in, not herein before. So we let go of 10 for the moment. We release 10. Qualifications and experience. Now let us come to 15.
Qualification.
What are the qualifications given? Ten goes, 13 comes in, 15 comes in, going only by the rules. Denial of promotion is wrong. Specifically provided for promotion, herein, in hereinafter, no requirement of graduation. Disposed.
One second.
Definitely.
13 melon.
Huh?
That 13 I'm reading melon. Promotion.
Oh, yes.
Vacancies in the cadre of administrative cum development section
Hmm.
and account section from one cadre to another shall be filled up
Hmm.
subject to the suitability as may be decided by the board.
Suitability has to be decided by the board.
By the board.
Hmm.
And by the appointing authority commission
Hmm.
as set forth
Hmm.
in Rule 14.
Hmm.
And also subject to possessing qualification and experience as prescribed hereinafter. So, my lord, the qualification is to be there.
That qualification is given in the rule. What is specifically given, we will not try to interpret. Is it not the law?
Yes.
Qualification given at 15. Qualification required for appointment for direct recruitment is not the language of the rule you are depending upon. When the language is there, when the rule is there, it is but every man's desire to take the shortest route out and not go for lengthy arguments.
This 15, it doesn't prescribe to the education qualification. Man.
Does it say in Rule 13 that educational qualification has to be as per the direct recruitment? Show us.
Well, sometimes we have to read between the lines.
We are not convinced.
Harry will come and my lord will seek promotion, my lord.
That is your rule. Let all Tom, Dick and Harry come and seek promotion because your rules are wrong. Are we to blame for that?
That is why, my lord, we are that 10 is, my lord, coming in, my lord.
10 is direct recruitment, nothing to do with promotion. You have a separate clause for promotion. What is specifically provided for will not be interpreted with the aid of anything else. Your Tom, Dick and Harry can have open doors for this body.
This qualification is general. You should not have two wives. These are the things, not this doesn't pertain to my education qualification matter.
Your rule. Introduce it. We'll reject him. Introduce at a point of time when he's right. Substitute it. take it back. You depended only on the rule with your opening arguments, and then you talk to this court about Tom, Dick, and Harry, sir. Is that the demeanor in the court? Where you ask this court, then if you pass this judgment, it is all Tom, Dick, and Harry. Can you say that in the court? You said, heard, we entertain with a smile, but we would want some level of decorum. Those are not words to be said to people.
My lord, I did not mean to offend, my lord. I'm trying to understand, my lord. Suppose, my lord, there has to be some for a senior assistant, my lord. There has to be some education qualification.
It is your rules.
That is why, my lord. That is why, my lord, we say that.
You did not say that you are refusing it.
Then-
You are saying that we are sending it. Did you say we are refusing it? Does your letter say so?
Yes, that is not there yet.
All your efforts to protect the interest of the department has to have some effort from their end also. We cannot take in an affidavit trying to explain what might have happened. Can we
My lord-
take in an argument to
My
explain?
lord, will come to my page 66 of that.
Yes, yes, definitely.
That minor, again, I'm reading, my lord.
Yes.
During discussion, I'm reading from the second last paragraph. During discussion, it is apprised by the managing director of the corporation as per the notification issued by the government. Government of Assam recently, in order to make recruitment to the post of junior assistant, the qualification of graduation is required. Though the above mentioned incumbent possess the qualification of HS pass, only they were recruited to the post of junior assistant. More prior to the issuance of the government notification. So, my lord, here.
Thereafter, what happened? What was the decision? That is the discussion. What is the decision on the matter?
After three-way discussion, the member of the committee decided to forward the matter of promotion of two incumbents to government for consideration of the
Approval.
of the-
Now, just for a moment, if we wait. Are we wrong in understanding that the board wanted the approval of the government to promote these two persons?
My lord,
Are we wrong in understanding? Yes or no?
my lord, no, my lord. Here is also catch, my lord. Why? Because, my lord, we run on granting aid.
Okay.
All the salaries we get granting aid, then only we pay.
Reduce the
So,
salary.
For anything, we take approval of the government. So that is why, my lord,
Approval for consideration for approval to reject or to grant the promotion.
no, my lord, we have sent it for consideration. Consideration.
To do
means,
what?
my lord,
To
there is
promote or not to
they
promote?
could reject also.
Promote or not to promote?
My lord, consideration means either way, my lord. They will give a
So
consideration.
who appears for the government?
My lord, this
Have
is
you made
social
government a
justice
party? No.
social justice and empowerment, my lord.
Have you made the government a party?
Yes, your lordship will can be seen. Government is party.
WPT and BC.
No, my lord, that is gone. I have informed this court many times that no, that department is not there.
Someone has taken over. Who?
No, my lord, there is now social justice and empowerment, new department, my lord. I have informed this court that I have told my friend, you have to make him party, otherwise that you have to.
Which
that's
are
what the-
This approval part anywhere required that things are
No, your
required to
lordship,
take an
your
approval of the
lordship-
government?
Your lordship will kindly see page 66 itself, your lordship,
Ah.
just above. What he is submitting is completely wrong, your lordship. In 66, your lordship, just above that, on examination other than Srimati Suborna Das, the remaining 4 numbers of senior assistants are found to be underqualified to be promoted to the post of Assistant Development Officer. As such, the members of the committee decided to recommend the name of Suborna Das to be promoted to the post of Assistant Development Officer. In her case, it was not recommended to the government seeking government's approval or consideration, your lordship. His argument is that in every case, we send it to the government is on the face of it wrong, your lordship. Number one.
My lord,
Now-
recommendation.
Wait, let me submit.
One after the other.
And secondly, if your lordship comes to page the rule again, your lordship, your lordship has already pointed out rule 13, your lordship. My case is not covered by junior assistant, recovery assistant to ADO and senior assistant. Next, junior assistant come typist to senior assistant. Here there is no question of ADO, your lordship. So far as junior assistant come typist. That means, your lordship, from junior assistant one can be ADO and from also senior assistant. For ADO, it's a different. And for junior assistant come typist, it's a different. Only
You are a junior assistant.
come typist. Your lordship will kindly come to page 17 of my writ petition. My appointment is junior
No, it
assistant.
was 6 and 7. He misplaced the numbers. He
Lords.
saw junior assistant, so that was marked.
Lords.
Otherwise, junior assistant to senior assistant falls within that administrative section and development section.
Lords, sir.
So everybody under that is covered by 13. Since it is covered by 13,
Lords.
we need not have a fault in that. We'll correct it in the order. We'll
Lords.
record it as junior assistant components. Yes, Mr. Dhar, you were saying something?
My lord, this is the meeting, what is your lordship? So my lord, we could not, we cannot buy the rules, we cannot promote. And what everything, my lord,
Your submission is by the rules you cannot promote.
my lord, we cannot. So my lord, that is why, my lord, we have sent it to the government. That is in the social justice and empowerment department, my lord. That is,
When did you send it to the government? Where is that letter?
my lord will come to page number 68.
Huh?
That is on 24th March 23.
Yes, sir. When the Social Justice and Empowerment Department was there in the affidavit in opposition, was it not necessary to be?
Lords, sir.
Brought him as a.
Lords, I should have them.
Suppose, my lord, his part, my lord, they have to take a call, my lord.
In fact, when I preferred the writ petition, that was this department was.
No. From 2022, that
24.
department is on roll.
Your repetition is of 24.
24. Yeah.
24.
There is a mistake on my part.
Anything more, sir?
No, my lord.
Any more?
This is
My part is.
this particular department, my lord. Our nodal department. From there, we haven't received anything. That is my instruction.
What Mr. S. Bottabul and counsel appealing for the petitioners also heard Mr. Ardhal and counsel appealing for the. Respondent number 1, 2, and 3. Not 1. Respondent number 2, 3, and 4. The respondent number 2 is the Assam State Development Corporation for Scheduled Caste, while the respondent number 3 and 4 are its instrumentalities. At the outset, it has been pointed out to this court that the state of Assam, represented by Secretary to the Government of Assam, WPT and DC Department, is no longer in. At the outset, it has been pointed out to this court that the Department of WPT and BC Department, WPT and BC does not, is no longer in existence and has been bifurcated into, yes, Mr. Dhar, bifurcated into.
Social justice and empowerment.
So, has been now renamed as the Social
Actually,
Justice and
bifurcated
Empowerment.
social justice empowerment is now taking care of this.
It, WPT and BC has been bifurcated into two, namely the
Department of Tribal Affairs
and
Social Justice and Empowerment.
Social Justice and Empowerment. Mr. Dhor has clarified to this court that the concerned department in the present case would be
Social Justice and
Empowerment Department. Mr. Bothapu has made a prayer that he may be allowed to file an amended post title in the matter to include the Secretary to the Government of Assam, Social Empowerment and Social Justice and Empowerment Department. Stop. Any GSM, Madam, can you represent that department?
No, my RM Das is there. RM Das.
Department, full stop. Accordingly, Mr. S. Bothapu is allowed to file an amended cost title in the matter on or before 13. Twenty-fifth of March, 25th of February, 2025. Stop. Extra copies of the repetition along with the amended cost title will be served upon the council for the respondent authorities, including Mr. R.M.
Das.
R.M. Das, standing counsel for the Social Justice and Empowerment Department. The matter has been substantially heard today. And it is because of the misnomer in the respondent number 1 and for correction of the same that final orders could not be passed. Please this matter again on 9th of March 2026 as a part-heard matter.
Deeply obliged. I'll do that.
Give this back to him.
Maybe the board wanted to give, but because of
Orders have been passed, Mr. Hur.
till 22.
We'll have it on the next week. Yes.
Kindly pass over the matter for timing.
Lordship and dear Lordship, in 22-23, almost same Lordship, only the cause of action is different. In item 23, we have filed an affidavit, but some issues were not been addressed, Lordship. So already have drafted one additional affidavit, Lordship.
22.
Item 23. Same.
22, you have filed your affidavit.
Yes, it is filed, but Lordship, some issues were not been addressed while filing the
That will,
affidavit.
you will bring the affidavit.
Yes, already drafted, Lordship, and send the betting on.
Is the same counsel appearing in both the
Yes,
cases,
yes,
22 and
Lordship, same
23?
counsel.
Ms. M. Bhattacharjee, learned additional senior government advocate, has submitted that an affidavit in opposition would be filed in, what is item number 23, in item number 23. Full stop. The learned counsel for the petitioner submits that they would be requiring an opportunity to file a response to the proposed affidavit in opposition. They may require a chance. Accordingly, Ms. Bhattacharjee may cause the affidavit in opposition to be filed on or before.
We didn't make, Lordship, it's already drafted.
Pick a date, we are not having it listed. Pick a date. On or before 20th of February 2026. With advance copy to the counsel for the petitioners. Full stop. The petitioners would be at liberty to file their response on or before the 6th of March 2026 with advance copy to the counsel for the respondents. List this matters again on the 18th of March.
Lordship. Deeply.
By stage lage hoga. Into affidavit in opposition in WPC number since at a line it has been submitted that both the restoration number so and so can be taken up together since they sell the same cause of action.
24 to 28.
Yes, sir.
In these cases, your lordship, on the
I need some time to file it. I haven't got the instruction.
lords, their affidavit will be required.
Will be. Mr. S. The Senate Council appearing for the Department of for the Higher Education Department has sought for an accommodation to sign a response to the repetitions. This the matters again on the 12th of March to be pending.
Basically more time. Because I have not received another instruction.
It is upon you to do it. 12th of March. You need more than a week.
4 weeks.
More than a month. So today is 13th of February. We were fixing it on 12th of March. 1, 2, 3, 4, okay, 4 weeks. Okay, 19th, 20th of March, 20th, do you know? Days. 23rd of March. 20th of March, 20 March. Yes, yeah.
29.
Yes, Mr. Dutta.
Last one.
Hello, we have received the instruction.
You are appealing for whom?
Assam Khadi Village Industries Board.
He's here. Is he here? On the
Maybe
said date, or either instructions were provided. Either, I left out the word either. Yes, all these salaries and other retirement benefits of any other person released during this time. Anybody receiving anything during this time? For the purposes of the release of a pensionary benefit, you need an audit report and your audit team is not there. What about the payment of the other things that are going on in the board?
This was the instruction sought for, and we have received this.
What was the instruction sought for as to why the pension is not being paid? Now a further instruction. Wow, what is the role of an audit team in pensionary benefits?
Regarding the misappropriation, is anything misappropriation is
By the petitioner. By the petitioner. She has been promoted, sir.
Yes, she is being promoted.
Is a DP against her?
No.
We are directing for stoppage of all wages of the concerned persons who are related to the payment of the pensionary benefits. We'll stop the salary of every person. Whoever is dealing with the file of pensions. All salaries stopped. Find out an audit team, pay the pension, start the pension, start your salaries. Should we do that? Then by what o'clock you can find an audit team to release the salaries? We'll give you time till 4 o'clock. Find an audit team, get the audit done, pay the salary. If the audit report is not required for the purposes of the pension, pay it without the audit. If it can be done subject to audit verification, pay the pension. But pay the pension. We'll have the matter again at 4 o'clock. He wants 2 hours less to your convenience. See, pension, to the best of our knowledge, does not require any audit report. 1 month before the person is supposed to retire, the pension papers are supposed to be ready. That is the law. You only have to release it. Let there be some misappropriation. Assuming there is some misappropriation, where is the money lying? In the provident fund. What is to be done? Pass an order, release it to her. She is a subscriber. CPF is a subscription provident fund. There is already a fund. She is not the person who has defalcated any money out of the fund. She cannot. You deduct it and pay it to the account. Pay her dues. At 2, find out why it is not being done. This is not an instruction. We don't have an audit team and therefore we are not doing it. In the absence of the audit team, the board would take another 2 or 3 months to get an order from an higher authority to have their salaries released. Let me assure you. That too. Anything?
Is it instruction in this method? Question में करिए अपन। The BTC has decided to lordship call for tender by adhering the principle of the auction manner in terms of Assam mines and mineral regulation. Pursuant to EC resolution.
Yes, do you have you gone through the orders passed in WPC 6716 of 2021? Answer the question. No. You have a good case. You have an interim order in your favor. Huh?
That is only. You have 20 lakh.
From where do you say that?
That is
It is the rule.
34.
Where is the rule?
34, Myla.
Rule
It's the
34?
mines or mineral concession rules from 30.
Assam shows the rule. When was the e-action held? When did you submit your tender?
Sale notice is of 29/11/2021.
21.
21, yes.
Okay. From 21, he has been waiting to be allotted that mahal. What happens?
Yes.
25. Now, just a minute. This rule,
So 18, amendment, Myla.
rule, this is,
Oh, your lordship.
no, you gave me this document. What is this document? You have given me this.
No,
The rule, where is the rule page?
34, your lordship, page 266 of this book,
266.
lordship.
Page
Page 266,
that is rule 30.
34.
34 is at page 26. Can we ask her which rule?
Assam minor mineral concession rules.
It speaks of an e-auction.
Yes, 34 2.
Yes.
That's it. Page 266.
Just flag mark it.
Yes. Must.
You are saying that the value is less than? You are saying that the value is less than 20 lakhs and therefore it has to go by what?
And the auction, they can go for the auction also. But this will look at this.
If they say it is for e-auction, then it has to be through e-auction. No.
Rule doesn't say so.
Shall. Mandatory.
My neighbor.
Uh-uh.
One young miner.
Huh?
Young the online method for BTC. He physically had added the work no other person.
Someone else is working.
That what is not available, but there, right? I mean,
So
but there is the person has not even participated in the bidding process, but his name was.
a public notice of 21 days shall be published, inviting withdraw conduct. In addition, e-auction under so and so above, gist of such notice. E-auction shall also be published in one daily newspaper having circulation in the area.
Earlier government did not take any steps, Your Lordship.
Yes,
We have
Ah.
taken resolution to that effect. EC has taken resolution to the effect, Your Lordship, to adopt the auction. And there is no question arises for giving allotment to somebody else where the sale notice has been cancelled, Your Lordship.
Yes, you did not give the e-auction. You give not.
Yes, now this resolution has been adopted. Lordship, the EC resolution.
So when the notice in this case was being published, it was
Yes.
given in the papers, but not in the, not e-auction. In addition to the publication of notice in writing,
Yes. Lordship, may I have a look at the?
e-auction under sub-rule 1 above, the gist of such notice, along with schedule for e-auction shall also be published in one daily newspaper.
Yes, madam. Lordship, this notice dated 25/8/2025.
38,
25/8/2025.
where is it?
Annexure 8 page 15. This is the NIT.
Yes.
Yes, it down below. Public Relation Voluntary Council for favor of kind information, wide circulation, free, widely circulated local daily. Pursuant to this, whether Lordship, any steps have been taken, that instruction I do not have, my lord. Whether it was circulated, maybe it is in your favor, that's why sometimes Lordship is aware of. One NIT is on
We
the.
will put up a board in between the two councils. I have told time and again, when one is saying, the other keeps quiet. As simple as that. Should we put it up on writing it there? Yes, yes, madam.
Assamese, borrow and English language, that instruction I do not have. Since Lordship, BTC has adopted that procedure, it's as per law, your
Any
Lordship.
case, madam, since the affidavit in opposition has not been filed, the interim continues.
Then we'll file our affidavit.
Otherwise, it will be her word against yours. Let it be in writing. Notice was issued on 3/12. Interim was granted on 8/12, fixing it for 13/2.
He moved it in the
Heard
last
Mr.
moment.
S. of Learned Counsel appearing for the petitioner, also heard Ms. V. Bhinal, Learned Senior Counsel, assisted by for the respondent BTC by the order dated 8/12/2025. This court had observed the absence of instructions on the part of the respondents and had thereafter directed the respondent authorities to maintain status quo as regards Bornodi Sen Mahal number 13 till today. Full stop. Today, Ms. Bhuya has placed before this court an instruction dated 11th of February 2026, conveying the decision of the Executive Council to adopt e-auction process while selling out mohals to successful bidder. Successful bidders by referring to the Assam Minor Mineral Concession Amendment Rules 2018, where competitive bids oblique open auction has been substituted by e-auction process. Full stop. We have the instruction also refers to the orders passed by this court on 29/10/2025 in WPC 6716 of 2021. Stop. List this matter again on 23rd of February 2026, allowing time to Ms. Veena to file her affidavit in response to the writ petition. Stop. This court has already noticed the delay being caused in the matter, and the learned counsel for the petitioner has submitted that the utility of a Sen Mahal remains only for a particular season, and that season is fast fading away now. Accordingly, list this matter again. Accordingly, the respondents are put to notice that in the absence of the affidavit in opposition on record on 23rd of February 2026, this court may proceed on the materials available before. We'll proceed on 23rd with or without the affidavit. We'll decide it.
Lordship is aware of how the government functions well.
But
Don't provide instruction.
it cannot be to his peril.
He also came very late.
They may have all the time in the world. The world does not have time. That is the problem.
Next matter is also can be fixed.
Same. Yeah, in this matter, you of the Sen Mahal, na? You took it, you write it down as Bornodi Sen Mahal number 12. Huh? Others, everything remains the same. Yes.
Lordship, I'm so sorry to mention at this hour. 15 till 15, can it be at 2 o'clock? Hearing matter.
Yes. Where is the original? Yes. 6/14.
6/12.
6/12. 6/12, 6/12. Then what happened? Okay. Where do we find the review medical board part? The signature?
Signature? 49.
Page number 49 we are reading. Just a minute. Top one is CMO's. What is SG? Senior grade. Yes. And what are these three persons? Any one of them in the I board? Are any of them an ophthalmologist?
That one is not.
That'll take you. That'll take.
One thing, Lordship, he is relying on a document of Sankardev Netral, but this is regarding near vision, and his rejection is of distant vision.
Where is the near? Where is that certificate?
N6. And
No. Where is that? This
50.
thing.
Page
Page?
50 is the Sankardev Netral certificate on which he is relying for. After the review medical report, he went to Sankardev Netral, and as per his submission that Sankardev Netral found both vision as norm. But this is for N6, and distant vision is the rejection, and N6
Probably
Where is
near
N6?
last one, follow up. And here also in the above also Lordship, right eye. 6/6 and 6/6 and 6. So N6 probably is near vision. And rejection is of distant vision.
N6 is near vision
What I found from net.
from the net.
Just now I have checked it.
Hmm.
But rejection is of distant vision.
What is VN? Follow up VN. 6/6 both eyes. Can you find out if the board had any
Lordship, that is just right.
this thing?
Whether any of them are ophthalmologists.
Ophthalmologist number one, the manner in which he was examined. The manner in which he was examined for the board to have said 6/12. Because if they're not ophthalmologist, I don't know how this conclusion would come. At least you would need that medicine or the chart. And that is one part. And the second part, you can have a verification. This, whether N6 and VN 6/6, what they do.
Whether what difference between distant and near vision.
Heard Mr. H.R. Ahmed, Learned Counsel, appearing for the petitioner. Ms. B. Sharma has submitted that the certificate issued by the page 15, certificate issued by the specialist hospital in ophthalmology may not be in relation to the distant vision. Full stop. She also wants to have her instructions. She also has requested to allow her to have instructions on the board which conducted the review medical of the petitioner and the manner in which the defects in the distant vision had been ascertained. Is this matter again on?
Fifth lot.
5th of, huh?
5th of March.
5th of March. 5th of March? On the 5th of March, 2026, allowing Ms. Sharma to have her instructions.
36. In this matter, we have filed the affidavit, but it has not been tagged.
What was the problem here? Dental one, you need to only count the teeth. Huh? Two incisors, 1.3 molars, 2.5 points. Acha. Huh. And what does your affidavit say?
Affidavit she has got some partial problem.
No difficulty, but
Affidavit is not required.
dental point 13, dental surgeon opinion is attached. Ask her to have the dossier.
For the dossier.
On the dossier. Have you received a copy of the affidavit in opposition? Would you like to go through it or? Show us. What we are relying. Where is the dental point counting? Saying? The point, get the point counted. Get the point counted. Each present. 3, 4, 5, 6, 7. Huh? 2 or 6 and 7. Okay. Hmm. 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 It will be 15. And you are saying 13. And he needs, how many do you need? 14. Average 13 plus 15 divided by 2, 14. Have the dossier available on the Mr. Tohvilder and Council appearing for on behalf of Ms. RDB has submitted that CGC has submitted that an affidavit in opposition has been filed. The same is not found on record. List this matter again on 5th. We are having the other case also. Okay. 5th of March 2026. The learned council, CGC shall requisition the dossier of the candidate concerned. Give this back to him. Yes, of course. Huh? Department has not paid. Yes, sir.
My lord, we have filed an affidavit, my lord. My lord, whether the second writ petition is maintainable or not, my lord, should maybe please to examine, because the prayer is similar. In the earlier one, my lord, it has been disposed of, my lord, basing on relying on that full bench judgment, my lord, regarding the first wife and second surviving wife in case of the Muslims, my lord. Now, my lord, here is the case. The my lord, first wife had been the petitioner had been divorced, and that divorce had also been duly registered by the government of Assam authority, my lord. That divorce has not been put into challenge, my lord. Now those things had not been disclosed in the writ petition, my lord, in the first also and in the second also, my lord. And we have bring those things.
His client had been divorced.
Divorce, my lord.
The divorce was by what means?
Divorce by following the due process of law under the Muslim personal law, my lord.
There has been one instance before this court
My lord.
where both the wives were benevolent enough to sit down, discuss,
My lord.
have proportional shares because her husband made a mistake. No chance in this case.
Lord,
It has to be swords drawn.
my lord, I have the attempt to for the such discussion, my lord, but this let my client, my lord, is being the my lord first wife, my lord.
He denied.
No, my lord, that agreement has been, the signature has been for the different purpose. My lord, I am not going into that dispute, my lord.
You deny that agreement.
My
We
lord.
will keep it at that we denied, you denied the agreement.
My lord. But my lord,
So-
if the, my lord, the first order by which the writ petition has been disposed of, if my lord may be pleased to find that order had been annexed at page 31 of the writ petition by my friend, my lord. The operative part, my lord may be pleased to find is at page 32, my lord. Paragraph 4, my lord. May I read, my lord? Paragraph 4. The learned counsel for the parties have, however, placed before this court a judgment dated so and so, passed by the full bench of this court in writ appeal number so and so.
Just a minute. This is under compassionate family scheme.
No, my lord, this is the full bench.
No. The person expired
Here, my lord.
in
Yes,
2023.
My lord, that
He will have two options, the family pension and the compassionate family pension.
that has already been got, my lord.
Which has been got?
The tenure for which the service remains, my lord, that benefit has already been got. Now it will come as a regular family pension, my lord. After the service period is over, my lord. 2 years service was there. My lord, that amount has also is due, my lord. That has not been, that amount is also due to this litigation.
Yes, that is what we are saying. That who appears for the government? You are appearing. Where is the compassionate family scheme? Where is the compassionate family pension scheme?
Scheme they have not annexed here, my lord.
That itself says that if it is permissible under the law,
My lord.
whoever are the family members who are entitled, they can make an application to the concerned department.
My lord.
And the concerned department would
Who will decide, but my lord, the full bench.
Apportion it.
Full bench decision, my lord, in.
That is a sub, that is with regard
That
to the
is
regular pension.
That is for regular pension.
Occupational family pension scheme itself provides
No,
that
my lord, under
if it is
clause
by
10, under clause 10 of that guideline.
5 point
Yes.
something.
5.1, my lord, 5.1 says, my lord, the
Down.
person, yes, my lord, the person concerned who is receiving the salary, he or she is entitled to, my lord, take care of the other family members, my lord.
And down below it says that anybody who is not being taken care of,
My lord.
please make a complaint, department will apportion it.
That is there, my lord. That-
Then why not that?
Now, my lord,
Once it is apportioned by the department,
nobody is being
it will
paid.
flow down into the regular pension.
Fine.
Please go and make a complaint to the department.
But she is no more a wife, my lord. That is the issue. my lord.
Eh?
She is no more a wife.
She will claim her entitlement before that
No, no, my lord,
particular
once she
department.
is not a wife and it has been duly. Mine. That can be, that can. I can be things.
Yes, when do you want it? Short date. April 6th. 6th of April.
But urgency is also on our part, my lord, because we're also not getting, and my lord,
Urgency would have been considered if there had been some consideration
no, my lord,
from either of the
now a
parties.
person concerned who is claiming, my lord, who is otherwise not entitled under the law, my lord.
No, we can direct them to pay 50% of the pension. We can release to your favor because
No.
anyways you are entitled to 50%.
My lord,
Rest will be held up
My-
till the decision of the court. That we
no,
can
my
do.
lord, whatever order my lordship is, we have to go
No,
down.
no, we can do that for,
My-
to take,
my-
but I don't want an emergency.
My lord.
To your benefit.
Survival. issue is
That
there.
50% we can ask you to ask to be 27. अच्छा जाएगा 27 ठीक है. After some deliberation in the matter, learned counsel appearing for the petitioner has prayed that his senior may be allowed to appear in the matter to argue, since questions regarding the validity of the divorce of the petitioner with the deceased husband has been brought up by the learned counsel appearing for the respondent number 7. Please stop allowing the prayer. Let this matter be listed again on the 27th of February.
Obliged. Obliged.
By the instruction that we have never asked them to close down the liquor shop. It's because of the complaints from the public, they are on their own have closed down the liquor shop.
And therefore you cancel the NOC.
The NOC has been cancelled by us.
Who has cancelled it?
It has been cancelled by the not Gauhati Municipal Board.
Huh?
Not Gauhati Municipal Board. They have cancelled the NOC.
Ah. No, then the municipal board has to appear. You have to say whether they could have cancelled it like this
Yes,
or not.
because one-
And whether that cancellation of the NOC would have any effect on his license.
It will
As
have-
of now?
Yes.
No. Have you cancelled his license?
No, we have not cancelled.
It is
that.
still on.
It's still on.
Why does he, did he have to, sir? Huh. No, no one is stopping you from opening the shop. We'll record his statement.
Yes.
License is valid.
Valid.
You can carry on your business at your risk, peril and at your risk and peril. The police, they made a party here.
No.
Then whom can we direct? Then we cannot direct anybody. Heard Mr. B.D. Paul, Learned Senior Counsel, assisted by Mr. J. Singh, Learned Counsel for the petitioners. Mr. Swansu appears for the excise department and has made a categorical statement that as of today, the license of the petitioner for the
Off license.
IMFL of retail outlet license has not been cancelled as of today. Full stop. There
And-
is also, this court in the earlier occasion had observed that the NOC issued by the municipal board had
Not-
been stated to be
Cancel.
cancelled, full stop. We do not find the municipal board to be a party in this writ petition, full stop. The senior counsel prays for an accommodation to take necessary steps in that regard, full stop. The learned senior counsel has also submitted before this court that the police authorities are not acting. No, that the police authorities, when approached to assist the functioning of the shop, had not cooperated, full stop. It is observed that the opening of the shop or IMFL shop would be required to be done by the petitioner with a valid license, and it is the duty of the police authorities to ensure that law and order maintenance is there to maintain law and order in case of any apprehension, full stop. The police not being a party in this petition, no effective orders are being passed as of now. List again on. You may file a proper implement application. In case we find there's a misnomer, we can ask you to file an amendment. But if we need to add someone fresh, you have to file it. When list again, and that will be your fight. It may have a new cause of action, we do not know. List this matter along with the implement petition filed by the petitioner, as and when filed by the petitioner. We are not fixing a date because it will be upon you to file an implement. You file it tomorrow, day after tomorrow it comes up. We are giving you that option. We are giving you that option. We are not delaying it. You file it tomorrow, you file it by Monday, it will be listed on Wednesday. If I say listed on March, your implement will keep hanging. Whenever you want to. Whenever you want to file it, have the implement petition listed, writ petition is listed.
Yes.
We'll fix a date for both. Yes, next.
Supplementary is prohibition 66 and 67.
Yes, sir.
That judgment to subject to favors me, because that is definitely quantified. That was with regard to and then they are not and this honorable court distinguished this. And then held that once the notification passes. But because it's school circumstances, the notification did not come. Therefore, that's not okay. But therefore, that's the they are also finding out
Dilip Das was, you were involved in Dilip Das matter? No. Were you involved in the Dilip Das litigation? No. In Dilip Das, there was already a litigation pending for which the provincialization was not being effective. In your case, was it the same? Huh? It would be better if you can give us a copy. Let us search it out. Can you give us a copy? You have one? No. Please go ahead. What page? Hmm. Hmm. 80. Ah.
The only issue in the case of green plus was whether a service to the regard to the the non-essential response is therefore submitted the judgment of the green plus was legally clear circumstance to the case is complicated to the fact that the measure is there is no notification to the second ten for fact. So here is the case where there is a notification and green plus was left out. But these are the systems where the notification was not there. And your option is time to time right of 44. Now the question. Now the question type is what consequence? Conjoint minimum section 1, 4, 1, 5, 6, and 10, 4. For the act of the public director shows the 10 for the act and the effect of distributing the benefit. State notification to be the employers of police benefit. Old person employment. The first state of the legal coming into force with the act of conduct. So it's not the legal from the data coming into force with the act, that's the legal. So in my case, now in our school, the notification about the issue.
10-4.
I was there.
10-4 notification was there, whether you could have been left up.
Yes. That is one. Secondly, madam. Secondly, madam. So for a cumulative normalized culture, it neither will not consider the living conditions nor the section 6 of the carrying of time, which was considered a no. It is totally silent on that. It only said that the Niyogi has setting aside, then the Niyogi set aside, and subsequently this jurisdiction was filed. There's sudden things where sudden saving policy made, and therefore this person there's no further requirement putting further issues. So that was not did not consider at all. No discussion at all. As well as general section 60 general law. That basically my assumption. But go into the aspects. So therefore, it is only more than to extends. Now, as your option to see the provisions of the living provisions compared to the what is the provision for district supreme committee. The purpose of this district level school committee is only to weed out those who are not eligible. But those who come within the eligibility criteria, they are completely equal. The moment the school is provincialized, if otherwise the person is ineligible, that will be and the district committee will be the mandate to see weed out those people who may not be eligible. Is their mandate is that because the living option is not subject to the financial restriction be coming. Their roles are specified and there is no.
You have challenged 31, page 31.
Yeah.
Is it not?
Page 31. Yet my question.
No.
That there is no case pending. The case pending, bill the case pending, therefore it becomes to the middle. Here, since no case is pending, therefore I don't have it right. That cannot be about.
No, it says in the instant case, although the name of the repetitioners were recommended by the concerned district scrutiny committee and state level scrutiny committee, no post was sanctioned for provincialization of their service. The names of the repetitioners were recommended by the district scrutiny and state level scrutiny committee and submitted to the government. But the government did not sanction any post. That part I think has been.
Because living provision to apply others. It's only to read out those who are not eligible. But the districts should be covered with the state level.
Yes, Mr. Kaushik.
Hello, in fact, in the peculiar circumstances in Dilip Das was that
Not only on that, now that Mohar Ali Sheikh has come. And on the last order, we had,
yes, that
Nidapar
petition-
Mahesh discuss on the Mohar Ali Sheikh case. That the impact of Mohar Ali Sheikh on
the writ appeal which your lordship indicated on the last order, that writ appeal is deferred till the review is done in the morning.
which writ appeal?
The writ appeal number 238.
Huh?
Sorry, 460.
Mohar Ali.
No, writ appeal 462 of 2023.
What is the name?
Indicated in that.
What is the
petition,
name?
Hello, the Sangit Doimari. There are
Sangit Doimari.
Debabrata Chaudhary, Anamika Deka.
No, we are on this. This
Anjan Kumar.
Mohar Ali Sheikh now says that the deeming provision comes into play. Is it not? At what stage?
In Mohar
In
Ali-
this particular case, we are trying to have it fit to see if it fits on in this case. In this particular case, the district scrutiny committee, the state level scrutiny committee have recommended it. Recommended. The post was not sanctioned.
In Dilip Das case, Malad, the post was sanctioned, it was kept vacant.
So that is different.
That is
Now, Mohar Ali Sheikh, it has said that the deeming provision will come into play. They had the right to be considered.
But in my respect, Mohar Ali in paragraph 1 to 112 to 118, it was in the context, Malad, because of the recognition and permission part in the subsequent act, giving it effect from that. Only those recommendations already been done by this in the earlier legislation, and that was kept pending, and because of the retrospective effect to the recognition part, in such scenario, it was statement. But if you're watchable, kindly take Mohar Ali's judgment once more. The discussion.
Tell us.
112 million, paragraph from 112 million.
We have to keep searching for this
If I read-
one. Mohar Ali?
Paragraph 112. In fact, paragraph 11 from 111 itself, 111.
Paragraph
111.
111. It would however be significant.
However, it is significant to note herein that from the materials placed before ours, we find that although the Act of 2011 was put under challenge in the earlier round, yet Section 3(1) of the Act introducing the cutoff date of 1/1/2006 was neither specifically put to challenge nor has the division bench recorded any finding as to the validity of the said provision. The fact remains that nearly 42,000 venture educational institutions have received the benefit of provincialization under the Act of 2011, which was holding the field for about 4 years before being declared by this court as unconstitutional. The Act of 2011 has since been repealed. Therefore, there is no scope for this court to reopen the issue of validity of the cutoff date 1/1/2006 inserted by the repeal act to the extent that the same has been continued in the Act of 2007. A conjoint reading of Section 3(1) and 3(2) and 4(1) and 4(2) of the Act leaves no room of doubt that there was a deeming provision under Section 4 of the repealed Act, according to which is subject to the fulfillment of the condition of the Act. The venture educational institution described in Section 3, whose employees have been completed 10 years of service without break from the date of appellation, recognition, concurrence, and permission shall be deemed to have been provincialized and shall become the government employees with effect from the date. As per Section 4(2), those teaching, non-teaching staff who had not been completed 10 years of continuous service without a break, their service will be provincialized with effect from the date of completion of 10 years of service. Thus, it can be seen that subject to the fulfillment of the condition laid down in Section 3 and 4, the teaching and non-teaching staff of those venture educational institutions coming under the purview of Section 3 of the Repeal Act would automatically be clothed with the eligibility of their services to be the provincialized under the Act of 2011.
Section 5(1) of the Act had laid down the terms and conditions of service of employee, according to which is subject to the provisions of the Act and rules made thereunder. All rules, including service rules and the rules of conduct of corresponding rights, shall be applicable to all employees of the educational institution whose service have been or would be provincialized under the provisions of this Act. Section 6 of the Act of 2000 had made it clear that with effect from the date of publication of the notification, under Section 4 of Section 10, the administrative management and control of all provincialized educational institutions coming within the purview of this Act shall vest in the said government. From the record available before this court, we find that a number of venture educational institutions or teaching and non-teaching staff under them had in reality attained the requisite eligibility for the service to be provincialized under the Act of 2011. In some cases, references 214 music teachers. We find that even the District Scrutiny Committee constituted under Section 10 of the Act of 2011 had verified their credentials, where the recommendations were also made on 6/6/2016 in favor of the provincialization of the service. Pursuant to such recommended, these teachers had acquired the status of a government employee under the Act of 2011 for all practical purposes, with only issuance of formal orders of provincialization of their service remain pending with the government. Therefore, we are of the opinion of a valuable right had undoubtedly accrued in favor of those teachers, music teachers, for issuance of formal order of provincial in their service under the Act. Notwithstanding the same, the service were not provincial apparently due to the repealing Act of 2000. Likewise, there are other categories of venture education which were established before 1/1/2006. They fulfilled the eligibility norms prescribed under the Act of and had applied for recognition permission before the concerned authority prior 1/1/2006 and had also received permission recognition from the concerned authority. But merely because the date of communication of sub recognition and application was beyond 1/1/6, the benefit of provincialization service was not extended to this venture educational institution. Having regard to the scheme of 2011 and the various provisions contained therein, we are of the unhesitated opinion that in case of those ventures which were established before 1/1/2006 had fulfilled the eligibility norms prescribed under the Act of 2011 and had applied for recognition, permission, application before the conservatory prior 1/1/2006, a vested right had accrued in their favor to receive benefit of provincialization under the Act of 2011. In absence of any allegation of fraud, misrepresentation, malpractice on their part, the rights were accrued under this venture educational institution and the teaching nonsense for provincialization, in our opinion, could not have been denied to them merely on the ground that there was a delay in communicating the permission, recognition, affiliation, as the case may be by the concerned authority. So, my lord, this was in only with those teachers, my lord, whose provincialization has under the 2017 Act has not been considered.
If we have para 116 again,
My lord.
we find that even the District Scrutiny Committee constituted under Section 10 of the Act had verified their credentials, whereafter recommendation was also made on so-and-so date in favor of provincialization of their services. Do you find that line?
Yes.
Pursuant to such recommendation, these teachers had acquired the status of employees under the 11 Act for all purposes, only with the issuance of formal orders of provincialization of the services remaining pending with the government. Therefore, a valuable right had accrued in favor of those eligible teachers for issuance of formal order of provincialization of their service under the Act of 2011. Here the director's order says, District Scrutiny Committee, State Level Committee had recommended. Post was not sanctioned. Now going by this sentence of the Mohar Ali Sheikh, did they right to have an order of provincialization accrue in their favor?
But under the Act of 2011, after the District Scrutiny Committee recommends, my lord, the state will prepare a list.
This
forward
order
it to
may,
the government for
this
approval.
order may have been correct on the day it was passed. Punavati Brahmo, so and so, whatever you want to say, that yes, since the order of provincialization is not passed, it is, they will not be considered under 11, under 2017. That was an understanding. When Mohar Ali Sheikh says the District Scrutiny Committee is there, State Level Scrutiny Committee is there, recommended, that order remained.
But it
They are
116
entitled to an order. They were entitled to an order.
No, no.
Now this is conflicting according to you. These two views are conflicting.
But this 116.
Are these two conflicting?
No, Miller, because 116 is read with 118, Miller.
Eh?
From 1112 to 11A was concerning the issue, Miller, that the teachers whose recognition was, the school's recognition was 2006. So by virtue of the new amendment, Miller, in the 2017, where we have said that the order has to be from 2006.
What do we do with this sentence?
Miller,
Pursuant to such recommendation,
Miller.
these teachers have acquired the status of government employees under so and so for all practical purposes. What do I do with that sentence?
That issue, Miller, that was not an issue in in that division method, before the division method. That issue was an issue before the coordinate bench in Nirupama Baro.
It was an issue which, but for this thing taken up by its own. Even in that case, they have made a finding. And that we know, that is why we are not addressing that question at all.
Where there was a challenge specifically made with regard to uh, the recognition, date of recognition giving an effect.
Not only one case.
No, no,
While discussing the whole case, this discussion
yes,
is being made.
these paragraphs relates to the challenge with regard to that.
We'll have to rack our brains a little bit more. No.
However, Malad,
Find out the bookmarks from, huh?
in the coordinate bench judgment, Malad, in Nirupama Baro or in category, Malad, where the issue was whether this 10-4 is just an administrative order or it's a mere formality of issuance. Because 10-4 completes the process of
That is just Nirupama Baro is single bench. He is relying on division bench. School was not provincialized. Here the school is provincialized. This man was left out. We'll come back at 2. At 2.
Malad, I have some personal differences. Take up Tuesday.
There is no professional difficulty. It's a personal difficulty. When?
1925.
Huh?
Audio lock.
Goes to 24th or 26th?
24.
24, Mari. 26? Huh? The request of the council for the parties to address this court. Not to address the court on the queries raised on 5-2-2026. List the matter again on 26th. 26th of February. You can keep this back for the time being. That sentence is creating a problem.
Possibly it's a subsilent journal. That issue was not there.
You are not arguing anything. Based on personal difficulty. Yes, sir. Yeah. We'll have it on the next day. No difficulty, sir. Please.
Incomplete inspection I have got now.
2 weeks to complete the instruction.
They were supposed to consider the representation. They have not disposed of.
Item 72. You know, sir.
In the family admission.
Mr. B. Gogoi, Learned Council, Learned Additional AG and Standing Council, PWD.
Yes.
Has paid for an accommodation to have his instructions completed. Mr. B. Das, Learned Senior Council, paying for the petitioner, has put in objections that several times such opportunity has been paid for. Several times. Mr. Gogoi has submitted that he has got some communication, but they may not be sufficient. List the matter again on 25th. Wednesday. 27th of February 2026.
order, Tribunal Appeal 221, 2024.
Appeal succeeds. Judgment is set at naught and the conviction and sentence awarded to the accused are interfered with and set aside. Accused is acquitted of the charges under Section 7 of the PC Act 1988. Bail bonds, if any, stand discharged. Appeal disposed of.
Delivery of government. Item 61, WBC 81, 2024.
In the peculiar facts and circumstances of the case, and the fact that the petitioner had been allowed to superannuate without any allegations, her claim to salary up to 12/8/2010 on and from 29/12 to 1999, and her claim to give her the benefit of old pension scheme under the pension rules of deserve to be allowed, writ petition is accordingly allowed.
Pending item 5.
We will not hear in the morning. Perhaps a Passover was taken in the morning.
What was this matter?
The grievances against a speaking order, madam, which has subsequently been withdrawn. And the petitioners have been extended the benefit of enhanced remuneration. Our affidavit has verified that position. 27 out of the 28 petitioners have been given the benefit, and one of the petitioners during the pendency is expired.
They were seeking minimum pay scale.
Minimum pay scale.
That you have
has already
given.
been taken. Then as regards 3 petitioners, they're also claiming regularization. That would perhaps not be possible, madam, because they do not fulfill the 10 years criteria as on 2010/4/2006 months.
So payment of, regularization, you are contesting and the minimum scale has been given.
Already paid. There are office orders to that effect, madam. They're part of the affidavit.
The the rejoinder affidavit on behalf of the petitioners have been filed. Mr. B. Chaudhary appears for the APDCL, none for the petitioners. Mr. Chaudhary, non-standing counsel APDCL has submitted that the petitioners have been granted the minimum scale of pay as was prayed for in the writ petition. The question of regularization now remains to be adjudicated.
As regards 3 petitioners.
List this matter again on April of the hearing date, 21st of April, 2026.
Pending item 29.
Yes.
Sorry, but I will organize some. I had a word with the concerned person, madam. With regard to the audit matter, they have given me a abstract reply. I'm not placing it before last week. Only thing matter what I raise in matter. With regard to provident fund and the leave salary, that amount they are saying that they will be releasing before 31st of March.
We'll have it listed on the 1st of April. Because thereafter another question would come in the financial year.
But yes.
So that issue we will not allow to be taken on the 1st of April. Release whatever is their due. Take your time. We'll record it. It has to be done.
Right.
So we'll list it on 1st of April on your assurance that all necessities will be completed by 31st of March.
I'm being told, madam, CPF and leave salary, madam, with regard to gratuity, they are not being able to say that will be released within.
We will accommodate, if the other part is paid, maybe we'll accommodate on the 1st of April for the gratuity part. No, we are not disposing of the writ petition now. We are simply recording his instructions that the CPF and leave salary will be disbursed by 31st of March. Therefore, list the matter on 1st of April for further orders. Mr. Endekar, learned counsel for the petitioner, is present. Mr. P.K. Munir, learned standing counsel, Assam Khadi and Village Industries Board, has submitted before this court that the office has instructed him that the leave salary and the CPF amount due to the petitioner, one to the petitioner shall be disbursed on or before 31st of March 2026. List this matter again on the floor. Huh?
They provided me the amount also.
Give whatever you deem is fit. They have a dispute, they'll come back. Or we'll take it up on the next date.
Sure.
List this matter again on the 1st of April, on which date Mr. P.K. Muni shall provide this court the amount of the amounts which have been disbursed to the petitioners, full stop. It is observed that this extension to 1st of April has been granted only on the assurance of Mr. P.K. Munir on instructions that the leave salary and the CPF amount would be disbursed by 31st of March. Third of Then, sir, 3rd of April, you would have to be alone in the court. Huh? 2nd of April, yes. Even March is even 3rd of March is a happy holiday. So 2nd of April? 6th of April, huh? Yes, 6th of April. এটা আধা ঘন্টাটো কি হ'ল এইটো হেৰি মাতি আছিলে যে ডেট দিলি নেকি বিকশিক ডেট দিলো নেকি মাজত হেৰি আছে নেকি লেপটপৰ কিবা আছে নেকি which one
In the morning, my junior made a mention.
No, we wanted to see, this is an old matter if we are not wrong, very old matter.
We have received, one of the petitioner, he retired in the month of December. So if Lordship wishes to give that benefit to him, so on that day when he was eligible, whether the post fell vacant, Lordship, that for consideration of that way.
What is the no, what was the instruction required? We have the instruction.
We have the instruction, basic of vacancy position of the grade 3, Your Lordship.
You have the instructions.
As regards vacancy.
What more is
Date
required?
on which it fell vacant, that is not there, Your Lordship, in my instruction, which I received it yesterday, madam. Therefore, yesterday.
10 days. When?
Any date, after 10 days.
Pick
any
your
date.
date. Miss Bhia has, Miss Bhia and a senior advocate appearing
What a
with,
beast.
with the assistance of R. Das.
On 25th, my
For
lord,
the
February.
BTC authorities had agreed that the matter will be taken up on the 25th of February to have complete instructions. He submits that a part of the instruction has been received. Learned counsel for the petition does not object. List again on 25th of February. Yes.
Supplementary item 68.
Hmm. Hmm. Yes, sir.
Lordship, on behalf of the PWD, we have also received the instructions and we would like to file our affidavit.
The tender was floated by whom? PWD.
Lordship, we'll have to file our response regarding the various tender.
Huh? It was a scheme under the state disaster relief. You don't have any money under the scheme to
As per my
disburse, huh?
As per my telephone instruction, that financial section has been granted, Lordship.
Financial?
Sanction.
Huh.
now the same is with the sent to the finance department for FOC, Lordship.
For FOC. We'll have it in March 27th. The Learned Counsel appearing on, Mr. S. Dotto, Learned Counsel appearing on behalf of
Revenue and disaster.
the Revenue and Disaster Management has submitted that the financial sanction for payment of bills to the petitioner has been granted and the matter has been sent for FOC. List the matter again on 27th of March 2026. Mr. So-and-so Learned Counsel appearing for the Mr. B. Google, Learned Additional Advocate General, has submitted that an affidavit in opposition would be filed in the meantime.
Item 69 to 71.
Allotment of what? There is an affidavit on behalf of respondent number 5.
Respondent number 6 to 13, we have filed here. Lordship in item number 71, WPC 29.
I have item number 69 before me, 5908.
Lordship,
Let us go one by one. In this, there is an affidavit by the respondent number 5, who is the chairman. And do we need any more pleadings in this?
Yes, Lordship. In this particular case, I am not there, Lordship, so I will not submit.
Then why do you say yes?
No.
Any more pleadings required? Any more pleadings required in this matter? No.
No, in 2960 pleadings are required. Lordship.
What would be required?
Item number 71.
71 to do. Pin number item.
No, let me submit.
Yes.
Lordship, in this case, the challenge has been made to the allotment of the private respondents. 13. We have filed our affidavit. In reply, they have submitted their affidavit. In affidavit, they have annexed the parawise comment of the chairman of Golpara Municipal Board, sending to the Director of Municipal Administration. Lordship. But officially, from chairman of Golpara Municipal Board, there is no affidavit as on today. But we require the affidavit because we need to know the extent of the Golpara Municipal Board. Lordship. Because as per in instruction, as per the document provided to.
Are you appearing for the board, madam?
Chairman Municipal Board of.
We are in item number 71. So this is a matter of 2022.
Chairman was not one of holding the chair.
We are concerned with the post. Allegation is of wrongful allotment of shops. Now, Nisiudas Learned State Council.
And
You appeared on 7th of January.
And one more thing, Lordship, the challenge has been made to the orders issued by the executive officer, Golpara Municipal Board, Lordship. But executive officer is not met party in the instant case, Lordship.
That we will decide when we are taking up the matter as a whole. So, madam, by when would you file your affidavit? This matter is pending. This is an item 71. This matter is pending since 2022 concerning the allegation of an unlawful allotment of shops by a particular municipal board or by its instrumentalities. The board has chosen not to file their affidavit still now, their response till now. Ms. Yudas Learned Counsel appearing for the board has assured that the affidavit in opposition would be filed on or before the date 26th of February 2026. List this matter again on the 9th of March 6th of March 2026, by which time the petitioners would be at liberty to file their reply. The private respondents would also be entitled to file their reply on or before the said date. এইবিলাকত লিখিব, on the other two writ petitions, right, list along with WPC number so and so. Interim orders operating in any of the writ petitions shall continue till the next date.
For orders, item 40.
Receipt from instruction. Maybe please to kindly parrot this way.
When did this incident take place?
Way back in the year 97, 98, 99.
And in 2026, the subcommittee has been constituted.
So constituted what has happened here, my lord. Now incidents, my lord, occurred in the year 97, 98, 99. Then first round of writ petitions, my lord, were filed before this honorable court. Those were disposed of. Finally, in the year 2012, my lord, the final writ petition was filed, where, my lord, this honorable court was pleased to issue a mandamus. That they say, my lord, that at that point of time, on account of ethnic violence, my lord, the authorities, that is the state government, involved their machinery to find out as to, my lord, who are the affected persons. Accordingly, 4 groups were called out. First group of persons who who could leave the relief camps on their own, and they can very well go and settle in their, my lord, native place. They were not given any relief package. Now their second group was that, my lord, to whom some security has to be provided so as to escort them to their native village. Third, my lord, that they were there for some time in the relief camps, but they could have, my lord, by passage of time, they voluntarily, my lord, vacated the relief camps, they went out. Fourth group of persons who were not able to, my lord,
Go back.
leave the relief camps and go to their native place. So the government took a decision that since they were unable to go to their native place, so they were given one-time, my lord, package of compensation 50,000 each to each family. That this 50,000 at that point of time would suffice for.
Then there was an enhancement.
Granting them the benefit so that they would be able to purchase some decent land and then settle there. Now, so far as all the other category of persons, those categories of persons were given 10,000 each. That is the admitted position. These people, they can, that they fall within the fourth group. So 10,000, 50,000 minus 10,000. So they had claimed, my lord, for the balance amount of rupees 40,000. Then this honorable court was pleased to dispose of the writ application, stating that, my lord, they were found to be suitable for entitlement of that balance amount. Accordingly, the authorities were directed to carry out a verification exercise. It was put to challenge before the writ appellate court. Now the writ appellate court, after a prolonged period of time, finally in the year 2022, it was the writ appeals were dismissed. After that, my lord, the state has now preferred review petition. That review petitions are pending. That is the factual matrix I have to apply.
No, then we were smiling on a different, totally different aspect.
Nonetheless, since these contempt petitions are alive, so we cannot, my lord, resign from the contempt petition. We are duty bound to comply. Really, this mechanism has been involved. The high-powered committee has been constituted.
We will, your last letter of 12/2/2026, the instruction, it asks the reports to be submitted by the District Commissioner Kokrajhar and Chirang
Yes.
on or before 25/2/2026.
Yes.
So what we will do is we'll 25/2. We'll put it up on the 9th or 11, 12, 13 March, whatever date you want to. In case the district commissioner of Kokrajhar and Chirang districts do not come up with the requisite reports, let them be present here. Tell us what is what is so difficult about.
I am not representing the district commissioner. I am representing my lord the.
Who represents the district commission? Please.
One document, of course, Lordship would like to peruse it.
Please.
That bunch of documents, my lord,
Ah.
the one representation has been filed, it is my lord. 6 page, my lord, I'm so sorry, I have not designated.
No
it, my lord.
issues.
This is a communication by the affected person. Now, this is a society before this honorable court. They include, my lord, large number of families, almost 6,000 families. So incidents happening way back in the year 1998. And to assess the damage.
They have asked for time till 11th of February.
Yes, 11. So in fact, they were seeking further time, my lord.
Have you given it to them, the list, on 11th of February? Kindly answer me one question. He is asserting that the petitioners, on behalf of petitioners Anthony, Francis, Utpal, Mohan and Samiran, have signed saying that please give us time till 11th of February 2026 to furnish the particulars. Have they done it with your within your knowledge, or have they been approaching the district commissioner for time and instructing you to pressurize the contaminants? We need to know. They have not informed you about this letter. In school time, we would have said cheating. They are asking for time and you try to run on with the content. If it is difficult for you to give the details to the deputy commissioner, kindly imagine what a difficult situation he is in. Can you tell us the number of writ petitions? Can you tell us the number of writ petitions pending in this court? No. Can you tell us the number of contempt petitions of the year 2026 pending in this court? We are asking for 3 months. Can you say? No. You are a officer of the court. You don't know. That cannot be. The deputy commissioner keeps changing. There is an office true. He asks for help. You say, give us time. Let us give them some time. Yes, this cannot be denied by you. Urgent, ADC, revenue, write a letter, so and so.
No.
We will have it fixed in April, end of April. In the meantime, have all your details put up to them. 25th is the day where the deputy commissioner is required to put up the, if you go to the last page, reminder. 25th time has been given. Today is 13th. You have 12 days. He has 12 days. Give it to him by 17th. He'll feed it in the computer, take it out, send it by 25th. Why? Why?
They are not cooperating and they are in a hurry. They want to have that quick and.
Therefore, we will record that we are giving them the time extended till April 2nd week. We'll bring it pre-bihu, provided the petitioners cooperate to give the details as and when necessary. March, provided the petitioners cooperate within 20th of February. Mr. R. Pujari and counsel appearing for the
My lord,
respondent number 1.
Respondent number 10.
Respondent number 10 has submitted that the deputy commissioners of the BTC of the Kokrajhar and Chirang districts have been requested to forward the reports by 25th of February 2026. Mr. Borpujari has also submitted a document by which in which it reflects that the petitioners, when asked to submit their details, had sought for time till 11th of February 2026 to furnish the details as available with the petitioners. Matter relates to ethnic violences which occurred in the year 1997 to 2001. Full stop. List this matter again on the 6th of April 2026. The petitioners shall approach the offices of the District Commissioner of Kokrajhar and Chirang as the case may be, with all relevant particulars on or before 20th of February 2026 and submit the details. The Deputy Commissioners of the particular districts shall also inform the petitioners the requirement of further documents for preparation of the report if so required. It is noticed that none has appeared for the, yes, are you appearing? You are appearing. For whom? Respondent number? The Learned Council appearing for the respondent number 567 is put to notice of the order passed today, which shall communicate to the present Deputy Commissioners of Kokrajhar and Chirang district for their appraisal. List again on 6th of April. You cooperate, will have the reports prepared.
The difficulty has arisen because of the fact that if the incident gets for to a prolonged period, that is the only reason. Otherwise, if the data is available, definitely the authorities will swing into action. Okay, to that extent.
We have seen the swinging action when data is available. Sometimes they swing too far. Yesterday, in some matter, the order was on compliance of the instruction of the Gauhati High Court. Entire period of suspension is regularized as on duty for all purpose. Writ petition was still pending. We were allowing the respondents for instructions. So on our instruction, the period is regularized. Sometimes the swing goes too far.
That is the medicine. That is the.
Yes, next. 41. Yes, sir.
Petition 2015, order of the High Court of 2018, content of 2019, and now we are in 26, the order is reflects very soon. Attendance there. On one, after they are not complying, straightforward order of the Honorable Court and 828 of the content petition. And on the last petition, they say that still now they are
Yes. I think there is a mistake on the in the earlier order. We said you were required to take instructions. Typographical error on my part, huh?
Place one instruction today.
What is that instruction? This one?
Yes, sir. Earlier, the colleges were to give the documents, now the instruction is that all the documents from all the colleges has been received. Now the department is sending this to the government.
No, we hold this to be contempt. You will send the proposals subject to availability of budget provision. Our orders were to pay them their salary. We are not concerned with their budget provision.
No, what has happened, my lord?
No, have the order modified. Have the order in the writ petition modified. This budget provision, this sanction, this FOC has gone too far. You are not disputing the claim?
No.
No appeal filed?
No.
Finance has not filed an appeal. No one has filed an appeal. We'll hold the finance liable. We'll hold you liable. Matters are not appropriately apprised to the court when the orders are passed. And thereafter, the person has to go around in a contempt. You could have said that please sell off our schools and our head office. Say, sell off our vehicles. Pay. Pay is pay.
In between, the delay actually that time period, that time period was because some documents were required,
From?
the colleges authority, my lord. And petitioners is also well aware, my lord. There are various petitioners from various colleges, my lord. Documents where they were giving the documents, then thereafter some modification.
Who delayed it?
The
The colleges.
Yes, madam.
So
Now,
we'll have the
recently-
colleges before us
recently
also.
on last occasion only, we have received the, not last occasion, my lord, if my lord kindly see the last order. On last order, we were yet to receive the proposals, my lord.
When
From
did you
all the
receive?
colleges.
When
Now,
did you receive?
from this letter, it is not reflected, my lord, the date, exact date, but it is said that has received from all the colleges, my lord. I am directly informed that this director has received all the individual.
No, we need to know the meaning of this sentence. Subject to availability of budget
Yes.
provision.
That part is one of the.
How many series of orders of the Supreme Court do you need to have to be explained that budgetary provision, finance is not there, we don't have the money, cannot be reasons for us to delay.
Lord, kindly give me 2 weeks time. I'll communicate with the authority, my lord, and to the needful, my lord. Otherwise, this is on process, my lord. Otherwise, my lord, this is under process.
From 2019, 18. The orders of 18.
My lord, I have filed the affidavit also, my lord.
Okay. What was the
Elaborating the stage-wise development.
when?
Yes. You know, can be time. Make it for 8 years. September. In the month of September 2025, my lord, as per the direction of the Honorable Court. We have to change how officers that change.
But Mr. B.D. Kaur, Learned Senior Counsel appearing for the petitioner also heard. Mr. S. Das, Learned Counsel appearing for the respondent number.
6, my lord.
Respondent number 6.
Oh, sorry, sir. 4 and 5, my lord. 4 and 5.
Who is 4?
4 is, my lord, the earlier secretary, my lord. Yes, yes. 4 is.
If the steps been taken on 7 and 8?
Mani Vanan and director, earlier director. 5
Just a minute, just a minute. Has the steps been taken on 7 and 8? Who appears?
We have filed a,
What do you say?
we have given a concurrence, so the entire process has to be taken up by the administrative department.
Concurrence means that they will give you the bills and you'll make the payment.
Yes, for that we have given the, so they have to make all the budgetary provisions. They have to assess the entire process, Lordship. They have to, and then Lordship, in our para 4 only we have stated.
So can we say in the order that finance has nothing more further to do? They will assess it and make the payment
Yes,
from their
yes,
coffers.
yes.
It would not come to you for sealing or sanction or SIU
So,
format or anything.
Lordship, that might come, Lordship, but provided they have to initiate. The moment this any approval is required, Lordship.
Now, once there is a court order
Yes.
and they gave you a calculation,
Yes.
would you be sending it back to them saying that please clarify what is
No,
the exact man position?
Lordship, ma'am, if there is some lacuna or there is some query regarding, Lordship, these are really technical issues, like if there is any doubt or sometimes the proposals are incomplete.
Hold the
Lordship,
person who has given you an incomplete or a bad proposal, hold him to task. But should it delay the compliance of our
No,
orders?
Lordship, here, Lordship will see, Lordship, it has not reached the finance department in any way. Lordship, we have already given a concurrence, we have stated in.
We are not taking you on at the moment. So show us that respondent number 7 and 8
7
have
and 8 has
been
newly been implemented, man.
have been, are being represented. We have implemented them.
Yes, sir. Yes. Right? Yes. We have already given a complaint, Lordship, the.
Yes, would you be appearing for 7 and 8?
I
Take
haven't
down
seen the
her-
service, whether service.
Huh?
I haven't seen one of the whether services from the.
No, no AD card or unserved notices returned back. Now respondent number 8 has filed the affidavit.
Yes, ma'am. Because at.
Through, someone has signed it. Who?
Because it was not party at that time, however, since there was a direction from this honorable court and the earlier incumbent was already.
Through you.
Yes.
So now included as an 8, so you'll be
Yes.
representing her. The service report dated 19/1/2025 reflects that AD card or unserved notice had not been returned back from respondent number 7 and 8. However, it is seen that respondent number 7 and 8, respondent number 8 had filed an affidavit in her capacity as the Director of Higher Education on 24th of September 2025 itself, laying therein stating the steps taken for compliance of the orders of this court. Therefore, notice of this contempt petition on the respondent number 8 is deemed complete. None has appeared for the respondent number 7 till now. Mr. S. Das, learned counsel appearing for the respondent number 8, that is the director, shall inform through the office of the director, the respondent number 7, that is Mr. N. Kaur, Secretary, the Government of Assam, Higher Education Department, regarding the pendency of the matter. Today, an instruction has been placed by Mr. S. Das, learned counsel appearing for the respondent number 8, that this individual area salary proposals of the petitioners from the concerned colleges have been received, and that the directorate would send the proposals to the government subject to availability of the budget provision for necessary financial sanction to release the said area amount. This court is not impressed with the submission that the proposal should be sent subject to availability of budget provision. Orders passed in the year 2018 for payment of salary are now being stated to be in the process of compliance only subject to availability of budget provision. The learned counsel appearing for the respondent number 8 shall bring to the notice of the respondent number 8 the observations made in this order. Mr. H. Oliha, learned counsel appearing for the finance department, has submitted that since proposals have not yet been received from the concerned department, the respondent number
6.
Your respondent 5 and 6, the respondent 5 and 6 could not take any further steps for compliance of the orders of this court.
Only 6.
Only 6, not 5. 6 could not take steps to comply with the orders of this court. The respondent number 7, to whose notice the pendency of this contempt case has been, to whose notice has been, the pendency of this contempt petition has been brought, shall file an affidavit on or before the next date fixed, detailing the steps taken for compliance of the orders of this court passed in WPC number The respondent number 8 shall also file an affidavit bringing on record the steps taken after September 2025. Full stop. The Learned Senior Counsel appealing for the petitioner has submitted that has prayed that contempt proceedings be initiated against the contemners, against the alleged contemners, since now it has taken more than 6 years for the nearly 6 years for the nearly 8 years for the contemners to even start the process of compliance of the orders of this court. List again on 1st of April 2026. 1st of April because the budget will go on the 31st of March and we would like to know what urgent steps you took. 1st of April may not be a happy time in case steps are not up for them. This is only to apprise the council. Yes, we'll have it on 1st of April. By that time, let.
Second, madam.
2nd of April. 2nd of April. Take 6th.
Yes,
6th of April.
6.
Pass a mention memo, we'll have it tomorrow. Have a mention memo or not tomorrow? We'll allow it for tomorrow is a holiday, so we'll have it on Monday. No, then. Bench 4 meter. File a mention memo on Monday, we'll have it immediately. Yes. Yes. 42.
Item number, I tender my sincere apologies, Lordship. There was some communication gap on my part.
Mr. H. Olihal and Council appearing for the respondents has paid for an accommodation today.
Today, Lordship.
Mr. Sharma does not object to the same if the matter is listed on yes. He says it was something on his part that has delayed the council's part. So far as Mr. Chaliha is concerned, it will never be a last chance if he takes it upon his shoulders.
Here, all the steps, I just need to place an update, Lordship. I've informed.
So, 16th February, yes, 16th February.
No, not 16. 15 to 20 days. Lordship, one.
Ms. Das, you need to control yourself, yes.
Lordship, I has. Not.
6 months, 6 months.
6 months. Yes.
6th March.
Yes, Lordship. That's much of that.
6 months.
43.
My lord, in order rejected the lordship's name, so my lord.
One of the impugned order.
In some other bench, oh,
Huh?
in some other bench, oh, what?
Some other bench.
Now, page 9, my lord. Page 9, order dated 16/3/2022. Art Mr. R.C. Soika, Learned Counsel for the petition, and Mr. R. Mojumdar, Learned Counsel for the respondent number 1, 2.
Should we say with a heavy heart or a light heart? List this matter before a bench without me.
44.
Can we take it up? Can we take it up? Petitioner's name? Petitioner's name, can we take it up? Have you seen the petitioner's name? Someone said we should not take it up. We can take this up. Okay, yes.
Lordship, one letter, your lordship, communication letter has been sent, your lordship, from DSC to Inspector of School Kasar. Here, your lordship, after getting this information, your lordship, the DSC has given direction, your lordship, as records are not available as records are not available, your lordship. Therefore, your lordship, it was given direction, your lordship, to the IS to send all the relevant documents. I would like to place it.
So if the admitted position is that the IS is not doing what he should have been doing,
The office has no available information whether the matter pertains to release of arrear salary or grant of MACPS benefit to the petitioner working at the Gauhati HS District Kasar. Pertaining to that.
what is your allegation?
After filing the salary, we need salary. Only one point is that income of MSC has not been paid. Yeah, still a great and agree.
So the second prayer at page 10. Pay the current and arrear salary from August 2023 has been met. Mr. V. Kumar Lanet, counsel appearing for the petitioner, has fairly submitted to the court that the petitioner's salary from August 2023 has been released to the petitioner after filing of the writ petition. Full stop. The issue now only remains with regard to the grant of the first MSCP benefit to the petitioner, which she claims to be applicable from. From when is it applicable, sir?
14.
From 2014 onwards. From 1/7/2014, full stop. The respondents to have their instructions on or before the next date fixed as to the entitlement of the petitioner on the for grant of benefits under the first MSCP provided under the relevant scheme. The matter is of 2023. Respondents are put to notice that on the next date of listing, the matter may be taken up for disposal, even in the absence of affidavit from the respondent on the basis of the statements made in the writ petition. Yes. When do you want it? Give us a date. Of? You will not have your instructions about MSCP. You are still hunting around for the person. Take something reasonable. 13th March. List again on the 13th of March. You give us a calculation, which should have been given by the respondents, which is supposed to be given by the respondents. Help them. 45. Yes.
Of my 3 days. 3 years. Not people
In this case, secretary has passed an order, my lord. But we have not received the final outcome.
I don't understand this. What? How do you ask the petitioner to publish 3 notices in newspapers regarding his claims? What was your claim? You are asking him to go for newspaper publication in 3 local daily newspapers regarding his identity and services? Did you do so? You got it published? Okay. Based on the report, Punjab National Bank, Notun Bazaar with back office was sent report on Iman Department examined the documents furnished so far and the certification of the documents of the certification which was not furnished with the instruction. Some crucial documents have attested paper, things down the hard copy, etc. Who is the alleged contemner? Yes.
Secretary.
Has he filed his affidavit? He has filed his affidavit. No. Instruction is by him. Has the instruction been issued by him? Has he taken any steps in the matter? Don't give us this. This is by some secretary, not the contemner. We need to know what the contemner has done. Sorry?
As per the order which is passed by the secretary, my lord, kindly see the last line of this order, my lord, speaking order.
Speaking order by whom? Who signed it?
Narayan Kaur, secretary, my lord. Next page, my lord, kindly see the next page.
Public notice.
Yes, my
He
lord.
made a public notice then?
Yes, my lord. Last line, he is directed to forward the findings of the inquiry to the department for further deliberation.
You take the D's job. You take the D's job. We are taking it up in contempt.
Director is not a party.
May not be. The secretary has not been able to comply with the orders of the court. He has not paid for extension of time. He has not shown how difficult it is for him to comply with a simple disposal of an appeal. We are holding him in contempt. When? When will he come back with to show causes to what kind of a punishment should be imposed upon him? After a week, this is heights. This is heights. Take down. They were required to take a decision as to the appeal file under the Provincialization of Services Act. Is he being properly advised?
To take instruction.
Yes, Additional Advocate General, sir. Very sorry state of affairs. Since we are proceeding, we are making up our mind to hold someone in contempt of court. We think your presence. What has happened is this. Claim for provincializing, some fight going on. Writ court says, file an appeal. Secretary will decide on the basis of records. I do not know whether she has a copy of this or not. In compliance, a hearing was conducted. Interim speaking order was passed in 2024, requiring petitioner to get a public notice issued in 3 leading dailies in Assamese, English and Bangla in their respective language of publications, laying threadbare his claims regarding his identity and services. Just carry it forward. Next paragraph. The report came on 21/8/2024 from the DEE. Then on the DEE report, another interim order is passed to take up the matter with the branch manager of Punjab National Bank, Notun Bazaar, for back office verification and authentication of the letter dated so and so. No physical letter is to be issued and forward reply. Department examining the documents and records furnished. As soon as materials are made available to the department, consequential speaking order will be passed. Any further consideration this court has to take into account while coming to a conclusion that this is a deliberate attempt to circumvent the passing of an order in the appeal, to delay it with all might that is available with the mighty government. You are asking a person who's asking for provincialization of service, an appeal to be decided. Three local daily newspapers of different languages. The person who's the contemner here has filed, to the best of his wisdom, only a vakalatnama. And the instructions have come from some lower authority who justifies and says that the speaking order will be passed when we have all the documents. Is he the person to send letters to this court? He is not a party. She said director is not a party. Mr. Whosoever, S.N. Chaudhary is not a party in this matter. The contemnor is not responding to us. We can invite him through proper channel. But before we do that, we will give that week's time on your intervention. I think he needs some advice. A disposal of an appeal under Provincialization Act of 2017. Is this the manner it is done? Has it been done in any other case?
Yes, we have done in their
A paper publication, state bank verification. In which other appeal, madam, has it been done? You have been representing the department for the last 10 years. Has it been done in any case? Not yet. Overnight orders are passed, not recommended by the DLSC, therefore rejected. Then again a repetition. Paper publication by a person asking provincialization, he'll be a tutor, 15,000 a month, asking him to go for 3 paper publications. He complies. Then a bank verification, he complies. So either it is the secretary, and if the I think the director has been sending the reports as and when necessary, so I don't need the director here. Yeah. There is one judgment of the Supreme Court which says not only non-compliance, but attempt to delay the compliance itself is contempt. With all the don't know, with the virtue, with the VC on to what extent can we express anguish? When can we have it, Mr.
On 25th or 27th?
On 27th of February, on 27th, this matter again on 27th of February. Mr. B. Gogoi, Learned Additional Advocate General, has been requested to assist this court in the matter. Good stuff. On the next date of listing, and the Learned Counsel appearing for the respondent number 1 shall take note that no affidavit on behalf of the contemnor has been filed till now. She would assist the Additional Advocate General with the requisite facts of the case and the pleadings available, and would also inform the Additional Advocate General on the next date of listing to facilitate his appearance before this court. This court has noticed that an instruction issued by an officer other than the contemnor has been placed before this court, which reflects that while deciding the case of the petitioner or deciding the appeal of the petitioner for provincialization, the petitioner has been asked to go for paper publication in 3 leading dailies of the Assamese, English and Bangla, and bank verifications have also been conducted. The court finds this a bit surprising, as in no other case this procedure has been followed while deciding an appeal under the provisions of the 2017 Act. Be that as it may, this matter will be taken up again on what did you 27th of February 2026 for further consideration regarding drawing up of contempt proceedings against the contemnor number 1 on this is sole contemnor.
46. Pardon, 46.
46. Yes, sir.
So the petitioner here has claimed that his period of 3F.
I think we are on orders in this.
Orders.
It is an orders column.
Not.
What kind of an order do we, is required today?
The counsel for the petitioner, he informed me that some service has taken respondent number 5.
No, respondent number 5, none appears,
Not.
but it is complete. It is complete. So, on the last occasion, it has been recorded. No, sorry, cut it out. The office note dated 28/1/2026 reflects that the service of notice upon respondent number 5 stands completed. However, none has appeared for him today also. Yes.
It's a date for.
What is the
The prayer is to consider his 3F period for counting seniority.
his period under?
Under 3F. Regulation 3F.
None appears for the petitioner today. List for admission again on. We'll have it in March of the auction admission, sir. 19th.
Not if it is possible in the month of February, can it be better?
February
February.
for seniority.
Okay.
You are more concerned than him. He's praying for whether 3F.
Senior.
February actually we are too full. Early March.
Early March.
11th of March.
Can it be on 10th March?
10th of March.
10th.
For admission. Huh?
I think 47.
Hmm.
On a technical point, it is hanging. Now they have got the wisdom now, my lord. The chief engineer is acting upon it, and within a short time we'll try to, my lord. Only 5 lakhs, my lord. She is a widow, and my lord, the money was due to her husband. Now they said that, my lord, she will have to be registered under GST. Of course, she is not here.
How can she be?
We have already informed now, and she has also submitted a representation which is there considering on this particular point.
We'll have it on 6th of April. By that time, have the when we are keeping it in April because we are giving you the month of March to make the payment. At the request of Mr. B. Gogol and Standing Council, PWD. Oh no, appearing for the. You cannot appear for the PWD, sir.
1 month.
For the respondent number 1, list this matter again on the 6th of April, as it has been submitted that the process of releasing the payment is underway.
Yeah.
In item 48, there is some, although the fixation of ceiling was received, there is some rectification as the contractors have changed their IFSC code. Right, the instruction.
Who has changed the IFSC code?
Yes. 850 of.
Why do you change your IFSC code when the ceiling has already been, you keep changing your accounts? Although by the last order, it was recorded that the ceiling has been released and the amount would be released to the petitioner in due course, the council today submits that due to the change in the structure of the bank, which was changed from UBI, from UBI, and has amalgamated in PNB, a fresh ceiling has to be released. The Learned Council for the respondent has submitted that the process is underway and the amount would be released on correction of the sealing. The copy of the instruction placed by the learned counsel for the respondents is placed on record. The request had been made on 29/1/2026. List this matter again on the 6th of April 2026, by which time the petitioners, the respondent shall ensure release of the fund. No, this was in item number 52. For 48. This is the order in item number 48 and 50. Okay. In item number 49, let's see, when the counsel for the petitioner has submitted that the orders passed in the writ petition have been complied with, writ petition, the contempt petition be accordingly closed on compliance. This so and so appears for the, not for the contemners, for the contemners.
51.
Have you filed the justice service? An affidavit of justice service has been filed by the petitioner on 10th of December 2025 and the same is on record. None appears for the respondent number 1 and 2. List again, what was the order of this court? What was the order of this court, sir? Where is the order of the court? He was terminated. He was terminated and his termination was set aside. Then what is the contempt? You have gone there to join. You have not been allowed to join. What is the contempt? Page 18 is the order of the court. What is the contempt? Have you been allowed to join? You have not been allowed to join. No, you have joined. Huh? Yes. At a scroll deduction, standing counsel forest. You cut out that order. We'll have it after some time. All of pisot matter. Scroll to your forest department. Let the forest department persons come. We may have some answer. So after some time, go through the file. Find out what is the order passed in the writ petition. What is the allegation made in the contempt petition? Why you say it has not been complied? If the order of termination has been set aside, you have been allowed to join, then that order has been complied with. If you are asking for consequential benefits, it is not reflected in the order that you would have consequential benefits. Right? So for that consequential benefit, you might have a writ petition, not a contempt petition. Find out. Edukiman. 52. Yes. Yes, madam.
Pay for further one month's time. Non-payment of contractual bills.
Madam Devi, how much you argue, we will not hold Mr. Gogoi responsible for commitments made in the court. He's a very assuring person. Representation made by the petitioner, date of the order is 73. Mr. B. Goel and counsel appearing for the respondent, for the sole, no, for respondent number one has submitted that, no, has assured the court that the respondent number one has, has submitted to the court that the respondent number one has assured that the orders of this court will be complied with within the next 4 weeks. Acting on such assurance, this court this court directs the matter to be listed again on March 27th of March 2026, along with compliance report to be supplied by the contender number one. Get us the
Maybe
he'll give us a report that we have complied.
not by one, by the respondent.
By the respondents. Compliance report by the respondent. None appears, no one appears for respondent number 5. On the last occasion on 31/2026, the court awaited the appearance of the respondent number 5. Today also none appears. No response has been filed by any of the respondent authorities. Have you filed?
It has gone for vetting.
No affidavit has been filed till date by the any of the respondents. List this matter again on 25th of March 2026, when the matter will be taken up for admission. Respondents are put to notice that the matter will be taken up even in the absence of affidavit in opposition, since enough time has been granted already. We don't have affidavits, we are not granting further time. We'll take up the matter as it is. Yes. Mr. So-and-so appears for respondent number 3 and has been apprised of the order. Now it will be on your shoulders. Cut out the reprise of the order.
Item 51.
Yes, 51.
Forest Department Lodge.
Why should the department defend a contempt petition? Entire department is at fault.
No, Lordship, I just call for your Lordship.
You were called for, yes. There is a order of this court which requires, this is item 51 pass over করাইছিল যে লপা করেন এটো নে এই মাত্র তো pass over হইছিল here what has happened is the order of penalty was set aside. He has filed a contempt petition. Representations show that he was allowed to join, but he has not given the benefits of the promotion or the area salary and whatnot. Dusty service has been taken upon the respondent number 1 and 2, who appear to be Mr. M.K. Yadav and Special Chief Secretary, Department of Forest and Environment, and Sandeep Kumar, PCCF. Dusty services, there none appears. We shall have to invite them by special route.
No, Lordship, the time I prefer department until the instruction in this contempt petition.
Mr. So-and-so appears for the, who usually appears for the Forest Department, has requested the matter be taken up after a week. Instead, the petitioner has filed an affidavit of dusty service, of effectuating dusty service on the respondents. List this matter again on
27th, Lordship.
27th of February.
Outline.
55.
Yes. An extra 20 of the, we should go. When did you join? When did you join?
joined on 6/12/1999, but he.
Sri Ranjit Burman was transferred with post to Dula Khan School. Thereafter, Ranjit Burman's adjustment replaced the vacant post of Anjali Chaudhary. What was the order passed in 2016? Some repetition in 2016? We have a look at that. Page 55. His case was placed before Sudhendu Mohan Talukdar. That committee, expert committee. Then what happened? You know, what was the result of the expert committee? And then what happened?
There are seven correspondence are there as well. Can you read the Excel 17 page 60? All correspondence are there. Documented. Already with. So 1966 also. Everything is done, but there was no part.
No. Mr. MP, page 59. You are representing whom? Secondary department. Page 59.
Then.
From elementary to secondary. Then page 60. From director to special commissioner. Yes. Then from deputy secretary to director. Is it?
Yes.
There is an expert committee report. The expert committee has given some report. And the deputy secretary has now turned the table saying that we'll go into the appointment part of it. Not his job. This court required the expert committee to do it. True. Expert committee was required to do it, page 50 something. Madam had shown 55. Please see page 55. No, page 56. 57.
Yeah.
The director of secondary education, who in turn shall place the case of the petitioner before the expert committee. And expert committee will pass a necessary order. Then you would have, this was sent. It was placed before the expert committee, and that is page 59. Elementary education says this is the decision of the expert committee. There's some decision. All you need to do is implement it. If the expert committee says he is eligible, give it. If the expert committee says no, pass an order saying no. Now he is working, so we are giving the current salary. In the absence of any instructions, current salary. And why this report is not being sent? This inspector of Nolbari. How were you appointed, madam?
No, but do you, have you anything regarding your salary? Then why did you approach this court? For what? No, you said you were receiving salaries from 2006 up to 2006. Then what happened? You stopped getting salaries. Then you approached this court in 2018. Sorry, 2016. Page 54. From 2006 to 2016, you approached the court in 2016. Court says go before the committee. After that, you have not received any salary. What is your proof that you are still working? Page?
Page 69.
Yes, the headmaster in charge forwards it. So no doubt he's working as of today. The petitioner had approached this, heard Ms. K. Devi and a counsel appearing for the petition. Also heard Ms. H. Taranpil and a counsel appearing for the
1 and 2.
1 and 2. The notices on respondent number, who is for? Respondent number. The respondent number 4 is yet awaited as per the office note dated 11/2/2026. The respondent number 4 is the headmaster of a provincialized school or a government school. Government or provincialized? Is a school, is the headmaster of a school under the control of the IS and under the direct control of the state respondents. Therefore, Ms. H. Taranpil appearing for the state respondents should also be representing the headmaster of the school. It's a government school, not a private school. The post. Next paragraph. This writ petition had been initiated after the petitioner was deprived of his salaries from the year 2006, and after the orders passed in WPC number 5392 of 2016 had required the expert committee to pass necessary orders with regard to the entitlement of salary by the petitioner. The earlier order of this court had recorded that the petitioner had failed to place anything on record regarding his appointment in Kolaguru Vishnurabha High School in the district of Nalbari. He had also failed to place the advertisement pursuant to which he had participated in the selection process for his appointment in the said Kolaguru Vishnurabha High School or an ex copy of his order of appointment in the said school. Be that as it may, this court had required the expert committee to take a decision in this matter after making proper inquiry. The expert committee has evidently submitted the decision during the minutes of the expert committee meeting held on 5/12/2020, and the same was also placed before the Director of Elementary Education for further action. Full stop. The Director of Elementary Education had forwarded the letter to the Director of Secondary Education since the school in which the petitioner claimed to be serving had been amalgamated with the school which now fell under the Director of Secondary Education. Full stop. several communications from the year 2021 onwards have been annexed to the writ petition, comma, some of them purported to be written by the Office of the Inspector of Schools, NDC Nolbari, and also by the headmaster of the Dolahal High School provincialized, and the deputy directors, the director, and the deputy secretary of the government of Assam Secondary Education Department. Full stop. Ms. K. Devi, the council has submitted that the petitioner has not been paid his salary as of date. Full stop. She prays that the current salary be released. The respondents are put to notice that in the absence of pleadings or absence of response to the writ petition before this court on the next date of listing, comma, this court may be constrained to take up the matter for consideration in the absence of response. Full stop. It is also made clear that if the matter cannot be taken up for final consideration on the next date fixed, the claim of the petitioner for release of current salary would be adjudicated upon on the next day of listing. List this matter again on the 8th of April 2026, by which time the respondents would be at liberty to bring on record their response to the averments made in the writ petition. You don't do it by April, we'll decide on whatever is on record. Do you have copies of the writ petition or is it missing? Eh? She will not supply again. You have to take it and make your own supply and give it back. Take her copy. It will contain notes.
56.
Yes. No, this is for orders today. What kind of orders?
My lord, I am appearing for respondent 1 and 2
Ah.
university.
Ah.
My lord, this case has been listed on a returnable date. My lord, I pray for 2 weeks time. I have received instruction, my lord. In the meantime, I shall file affidavit.
For your convenience, respondent number 2 had not received the AD card and yet he appears. Yes. Only.
That you already joined, man. He has been relieved and he joined his earlier postman as principal.
Ah.
Earlier because he left from principal. He was elected and registered. On the post of the register, he was relieved. Then he joined his earlier. So the grievance now remains that order was passed, relief order was passed on the basis of a recommendation of the BPC, where it was stated that.
You want to go back to the lien part? No, he was in a particular, he was under the BTC authorities. He went and joined somewhere on lien. Then he was released from that lien, he came back to BTC. Now he has gone back and joined on the lien post again. No, what is your grievance today?
Grievance remains on the test. So order was passed on the basis of the recommendation, which is schematic. Recommendation is of case 32. The recommendation was of Boroland.
Boroland University had released him from the post of registrar. And now where is he now? Huh.
Principal.
Huh.
The order, certificate was passed on the basis of the order, annexation case 32. That the two register of the Boroland University and Professor University. They control their student. Two students of the Boroland University and Professor University who vandalized the Boroland secretary. On the basis of the issue
Whatever be it, huh?
So on the basis of that,
The recommendation was made. Now what is your prayer?
my prayer is everything would not be to pass a place order delivery, and my salary has not been released
From what time to what time?
for the month of December. My salary was.
Yes, he has worked for December with you. You are appearing for 1 and 2, BTC. The BTC, university. University, who appears for university?
I am appearing.
Why don't you give him his December salary? You have released him on 30/12.
Well, we are filing affidavit.
No, we are giving him the salary. Then you be happy we have released him. Perhaps we will not go into the reinstatement part. Why will you hold back the salary? Who has held it back? Under what orders? See, the recommendation came on December 2025. You released him when? Sorry. You released him on 30/12/2025.
25.
December month he has worked. Has he been paid?
But he is, only he is to get relevant, can be here with me, Melon.
Oh, something is brought before a writ court. Man is not paid his salary for a month. We should not look into it. Then whatever you have not given in the affidavit in opposition, we will not hear it. Oh. Then? No completion of 10 years. That is for them to decide.
Well, the salary part was not there in the prayer portion, Melon. So I could not get instruction. I have to take instruction, Melon.
That you have not been paid the salary.
But
then you have not made a prayer. We reject it. You know it and you have not paid it. We reject it. That is on a faith, on good faith that you have made the prayer. File another petition. I have not been given my salary. We'll consider that.
I shall take instruction on whether they are going.
No, just tell us one thing. His only prayer is, let the release remain. Let those awkward words be removed. One vice chancellor, if you think that one person can stop an army of students, we have seen the students' agitation in 1980s. You must have been quite. At that point of time, you must have seen what students can do. And the VCD painted for it.
But the allegation was not imputed by the university, right? It was.
Yes, Mr. BTC. Who appears for the BTC? Madam, yes. Tell us, madam. You are saying he could not control the students. Is it not the pride of students that no one can control us? This entire matter can be brought to a quietus. He is ready to continue to serve as a principal of that college. He does not want to go back to BTC, the university. His only thing is, students will go from their home and break down the secretariat. Because they are my students, can I be held responsible that I could not control them? There are incidents happening in all the smaller district level authorities. Is it not? If you ask the director and tell him that no, you are not capable of controlling your districts, please go home. Can it be? He just wants that those words should be removed from the order. The order remains. He is no longer the VC. But those words of because he could not control the students. No, we are not saying that we are passing an order today. Not without your reply, of course, but perhaps you can talk with your department, the authorities, that the order remains. He goes as the VC. That is what he has stated in court. I don't want to go back as the VC. You don't find me fit, I will not go. But don't reflect it in the order that because of me the students went there or because I could not control the students. Remove those words. Give a fresh order. Therefore, we will have to allow the petition. Is it not? It was done without notice. No inquiry where he participated. Stigma remains. You cannot do it. Did you get any notice prior to this? Okay, when? When? They can they say no when the government says that please give me back my man? Will they say no? 2 weeks. We'll double it for you, 4 weeks. Double the time, but have your reply ready. Ms. So-and-so and the council paying for the BTC has submitted that. The affidavit in opposition would be filed within a period of 2 weeks. The Learned Counsel for the petitioner. Have you filed university?
No.
The Learned Counsel
I
appearing for
also
the
pray for that.
appearing for the Borland for the what? Borland University has also sought for some time, allowing such time. List this matter again on 27th, not 27th, 31st, 30th of March, 30 March. The respondents may file their affidavits in the meantime. Petitioner would be also entitled, would be at liberty to file response. Ask them if they can remove that particular word. We'll say BTC is benevolent, have removed the words, read petition closed, everything. Okay. Eh? He's after happiness. Please. Item 51. The bird has flown out of the nest. No, what we did was the standing counsel for the forest was here. We have requested him to take note that the dusty service has been done, and therefore we may not be in a position to, or we will be in a position to invite them through some special messengers, which we don't want to do. He will have his instructions in 2 weeks. And from what I have seen is that the order of termination has been set aside. You will order of? Oh, it was not a termination order. Okay. But then that order does not give any limitation, or it does not direct for the promotion to be given. You are only supposed to get back the increments. And that will be another cause of action, not in a contempt petition. That is to be given to you. He is having his instructions in 2 weeks.